All right, ladies and gentlemen, we're going to get started. We have a quorum, and I'm going to call on Representative Matt Reeves for our invocation.
Lord, we thank you for this time today in the Judiciary Committee in honor of the judicial pay bill we did today. We pray for all of our judges and the judiciary, and thank you. We're in a country with the rule of law. In your name we pray, amen.
Amen. All right, first bill to call up will be Senate Bill 19. Take care of our friend across the way there. And just let me know which microphone you want to use.
Is this one good?
Yeah,
Can you hear
that's
me?
Good. All right.
Thank you, Mr.
Now,
Chair.
this bill has been back, or has been before us before, and if you would please just go over any changes that have been made since then. And
Sure. I'm working from a substitute, LC 442504S.
okay.
And this bill may look very familiar to the committee. It relates to passport fees that are collected by Superior Court clerks and probate judges. The bill passed out of this committee last year after a lot of changes were made to it, but it was recommitted as it did not get called up for a vote in the House. I've made significant changes to the bill, and what it does now is it provides for quarterly disclosure by Superior Court clerks to the county in Section 1 and to the probate judges in Section 2. What it does not do is prohibit clerks and probate judges from keeping the fees as personal income, and it also does not comment on any formula for sharing the fees with the counties, although county resources and staff are utilized in most cases. My thinking on making these changes is that transparency is the most important issue here, so I removed all the other language that the committee saw last year.
All right.
Happy to answer any questions.
Any questions by the committee? All right, seeing none, thank you. I've got Deborah DeBerry wants to speak on the bill. Is she here?
No, we're in support.
You're in support? Okay, thank you. All right, any discussion about the bill? Do I hear a motion? Have a motion and a second. All those in favor say aye.
Aye.
Any opposed? Your bill's on to rules.
Thank you, Mr. Chair.
All right, thank you. And I'll give you the form here.
And the House sponsors represent Carlson.
Okay, thank you.
Thank you.
All right. Now, I think, where's our Secretary of State?
Can we go check?
Is Petrie here?
No.
Nope. I don't think I can go forward on that then.
I'll check real quick.
All right. I don't see Montahan. Unless he's hiding.
He's too tall.
Yeah. All right. Don't have Petrie, don't have Montahan. Whose is this one?
It's top policy.
Is that Tyler Paul? You ready to go on yours?
What, I've got the original that I'm gonna withdraw and substitute and just present the original. I think it'd be easier for them that way.
Okay,
So I've got my admin bring a copy of the original.
okay, we'll hold them. All right. Well, somebody's about to get behind a big bunch of witnesses here. All right, at this time, I'll call 1172.
Thank you, Mr. Chairman. Thank you, committee, for hearing this bill. I want to make sure I have the right LC number because we have went through several changes with this bill. All right.
Too late.
You ready?
Go ahead, yes.
Mr. Chairman, committee members, thank you again for letting me present House Bill 1172 to you. We have LC 550233S. That's the current version that I am proposing to the committee. Is that what you have in front of you, Mr. Chairman?
Hang on just a second. It is? Yeah.
LC 550233S. Very good. So, Mr. Chairman, you're intimately familiar with the study committee we had in the off-season. And the study committee's purpose was to try to bring some solutions to an area of law that is a lot of times problematic for our enforcement officers and over at the DNR, and it surrounds the surrounding issue is with regard to navigable waters. Last year we passed Senate Bill 115, and there were many folks, many in this room and many that followed the study committee throughout the month of October that had problems with the language in Senate Bill 115, and one of the problems with the language was the reference to the public trust doctrine. And after much deliberation with the subcommittee, or excuse me, the study committee, and many meetings around the state where we had a fantastic showing from the public with regard to this issue. I think we had more than 100 members over near the Sequoia that showed up to the meeting for a study committee, which was frankly surprising for me. But we did find out a great deal about that community and the community in the mountains when Representative Chastain hosted us. Ultimately, what we decided as one of the provisions and recommendations out of the committee was that we would remove the public trust doctrine language from Senate Bill 115 while retaining the underlying purpose for Senate Bill 115. So what you have before you is this. We removed and struck the language that recites essentially what the public trust doctrine is on lines 12 through 15. And recited in terms on 17, 18, and 19. The Assembly further finds that by common law, so without referencing the words public trust doctrine, we recited essentially what the public trust doctrine is. By common law, the citizens of the state have inherent right to the use for passage for hunting and fishing all navigable streams from the low water mark to the low water mark. One version of this bill that I had drafted was trying to address an issue with folks sort of sojourning on rocks, and that was part of the problem. And the genesis of Senate Bill 115 was a piece of litigation surrounding the Flint River, and what the plaintiff in that case was contending is that they had exclusive rights to the fish in the water and exclusive rights to the riverbed. And so, in other words, you couldn't stop fish or anything. Now, there was conflicting testimony as to whether or not they were the plaintiff was okay with passage, but ultimately they did say they were okay with passage. But what I've done here is recite that they're in a navigable stream, and it's important to recognize this is only navigable streams because the Sequoia is not a non-navigable stream, and the difference that makes is this: you own to the center of the thread, or the center of the stream, and if you own both sides, then you can essentially put a fence across it, and no one can pass up and down. And that's the current state of the law right now. But what Senate Bill 115 did, and what it does now, it only applies to a navigable stream. And here we struck the public trust doctrine language, and we recited as one of the other recommendations. We wanted to give some clarifying language at the end on lines 24 and 25 that nothing in Senate Bill 115 gives you the right on a navigable water to get out of the water and go on someone's private property. That was a large issue that many of the folks around Georgia had a problem with. They were afraid that Senate Bill 115 gave access to private property. And because we are a strong private property rights state, and we also recognize the importance of our fishermen and hunting folks, we want to balance these interests. Now, this is a delicate balance, folks. I mean, I can tell you, I've been walking it for like 6 months, and I look like I've lost weight, and it's just been stressful dealing with it all. But this is a very delicate balance here. We want to, one, allow folks to fish, hunt, and pass down our navigable waters, while at the same time maintain people's personal property rights. We don't want somebody going on somebody else's property. And that's what I sought to achieve with the edits to Senate Bill 115. And I think we'll hear testimony from both sides here. There is no perfect solution, I'll tell you that. I thought I had an agreement with some of the folks in the room, and it appears they rethought their line of thinking. And so I expect we'll hear from them, and I appreciate them giving me heads up, at least that they were going to be changing their minds. And I think it'll be surrounding lines 21, 22. In this line it says, well, I'll start at 19 here. The General Assembly further finds that the public retained the aforementioned right, even where private title to beds of navigable streams originates from a valid grant. But in such cases, the public's right is limited to only using such navigable streams for passage, for hunting, and for fishing. All right. So to me, what that says is that on a navigable stream, you can fish, you can hunt, and you can pass, but you don't have the right to get outside the bounds of the low water mark and go on somebody's private property. And I think even within this language, whatever's incidental to fishing and hunting and passage, you're allowed to do. I think opposition will probably have another idea of that. That's the bill, Mr. Chairman. I'll stand for questions.
All right. Whip Burchett, I want to thank you for chairing the committee and the hard work you put in to study this issue and to come up with a report, and also for putting this bill together. It gives us something to talk about, and this is an issue that is worth discussing. You do have a couple of questions, so let me start with Representative Kelly.
Thank you, Mr. Chairman. I'll just kind of echo what you said there. You know, last year when this piece of legislation came through, kind of late, I was one of the ones who, because some of the other work we've been doing in here extensively, was confused on the subject matter. And, you know, like we do up here, we have to make, quick decisions, and couldn't support the measure last year because I just didn't have an understanding of the full legal concepts at the time. I appreciate the opportunity for us to have a thorough review during this off season, because it is something that's extremely important for our state in terms of balancing private property rights while also continuing to be Georgia. And one of the things I think is great about Georgia is being able to hunt, fish, and float down the river. And I love doing that. So, but I guess my question, I just want to try and make sure for my ease of mind, do you have concerns or do you have any interpretations that what we're doing today would restrict passage on waterways in Georgia?
I don't think it. No, and thank you for the question. And by the way, Senate Bill 115 wasn't my bill. I was just left to fix it. No, I don't have any concerns whatsoever that you're going to be, and there's going to be any impediment of passage in navigable streams in the state of Georgia. Now, that doesn't mean that some landowner won't claim that a landowner says that I don't believe it to be navigable. The interesting thing about a navigable waterway, everybody in here is probably thinking, and navigable means that you can put a barge or a ship on the stream or the waterway. But the fact of the matter is, definition doesn't support that. You could barely walk down a stream that is deemed navigable in certain times of the year. As long as part of the year you can conduct merchantable business on it, it is deemed navigable.
Thank you for clearing that up for me.
All right, who's got number 6 over there? Representative Evans.
Thank you, Mr. Chairman. A couple of questions. First, I was wondering how much area do we think this bill applies to, and how much of a problem were we actually seeing? Like when you say you're not allowed to go on people's land, I mean, is that, I'm truly curious.
Yes, this is so interestingly enough, that's a reasonable question, right? But in doing the research and being in this now for a full year, looking at this one issue, this is a very serious issue. In fact, on the Flint River. We've got a gentleman that's a property owner that I believe is serving time for shooting at someone that was trying to pass down the river. And so when you start conflating two different issues, navigable, non-navigable, and where your property rights extend, people get very passionate about that. And that's what we're seeking to clarify here. And a lot of times what's happening, Representative, is a landowner or a fisherman or a hunter is calling DNR to say, hey, you know, either somebody's on my property or somebody is trying to stop me from floating the river. And a couple things are true in that situation. Every one of the individuals in the middle of the woods has a gun on them. And if things get inflated, could be problems, and so we're seeking to fix that issue. I mean, if you're out there hunting, you certainly have a gun, and if you're out there trying to keep people off your property, it's likely you have a gun as well. So that's what we're trying to fix, and this is a very, very serious issue, and there has been multiple arguments and things that got really out of hand when it comes to this issue.
Two other questions, if I might. The first one you've spurred by your answer. I will admit it, and I will. This will be used against me in some campaign commercial one day, I'm sure. I don't have a fishing license. When you get a fishing license, do you, for the camera? I have gone fishing. I have gone fishing. I know how to fish with worms and all, but when you get a fishing license, will you get this information so that you know where you can and can't go? So
currently, the DNR has a website you can go to where they believe that areas are navigable. I'm almost 100% correct. Believe that to be true. I think I've seen it. Am I right, Mike?
They have a map, yes.
Yeah, they have a map. All right, so. And the interesting thing is that all of these boat ramps are paid for by you paying for your license and buying all your fishing gear so yeah, the short answer is yes. You can there is a map you can look at, and also. It is, if there's a public boat ramp that the DNR has put in, installed, and or is maintaining, then the DNR has taken the position that it is navigable. So you go to a public boat ramp, you should be able to float up or down the water.
Okay, thank you. And it may be that here or somewhere else, if we want to address the problem and we want to make sure that people aren't using self-help with their guns out in the woods, the more communication about what the rules are is probably better.
And so I'll be forthcoming and saying this. It is my intention to try and codify what is navigable in the state of Georgia. So basically try to codify a map that says this is what we deem to be navigable in the state of Georgia. And I think that ultimately is the fix, right? So instead of just a recommendation by DNR, what we think to be navigable, the General Assembly steps up and says, hey, these waterways are navigable from this point to this point, so that it clears this up. Now, it will be painful, I feel like, for a couple years, because the list is bound to not include something that people think to be navigable, and is bound to include something that people think not to be navigable. And so there will be an issue, I think, for maybe 2 to 5 years, and hopefully we can get over that.
The map idea is good. And then my last question is on line 16, where it talks about, this is not new language, I recognize, where it talks about, except where title in a private party originates from a valid crown or state grant before 1863. My mind immediately goes to a discussion we had in here a few weeks ago where we've basically passed a bill that's, I understand, is going to make it a lot easier to perfect these grants or for the private property rights to come into play. So do you have any concern that your intention, and I know there was a lot of work put into making sure that we have a balance and that people are allowed to hunt and fish, but private property rights are respected? Are we setting up a collision course where a lot more people are going to be claiming private property where people can't hunt and fish when we wanted to make sure that people were having that opportunity?
Yeah, from the very onset of this whole issue, that was, if we are going to seek out to fix this problem, there is the opportunity for folks that didn't know what the current state of the law was, that we raise the flag and say, hey, if you can trace this back to the Crown or state land grant that gives you exclusive rights, then it plausibly they could say, no, you can't fish or hunt here. So it could instigate some litigation.
Thank you.
But again, that was past last year's bill. I'm seeking to clarify it.
Understood.
Representative Silcox.
Thank you, Mr. Chairman. Thank you for bringing the bill and all your hard work. I know that the study committee was quite onerous, I understand. So thank you. I just had a quick question that is on line 22, where because my understanding is that navigable, of course, is a term of art, but the other word, my understanding is that the other phrase is rites of passage for paddlers.
Mm-hmm.
And so to me, we're limiting this just to passage.
Mm-hmm.
And to me, that's more vague. But that's just my opinion. Do you know if this is changing a term of art in the code, or do you not?
I don't believe it is, but I don't know for certain.
Okay, just from the case law and all. Just concerned because passage seems to me just broader. But traditionally, my understanding is rites of passage for paddlers.
Very good.
So
I don't have the concern. We added the passage language, but duly noted.
okay, thank
Appreciate
you.
it.
All right, Representative Reeves.
Whip Burchett, you talked a lot about navigable, definition of that, with the Flint River being one of the impetus of the statute last year that we're revising here. Stream, what's the definition of stream versus river?
Now, that's the first time anybody's asked me that.
Because I mean, the Flint River's huge.
I don't think it.
Streams,
I don't know that the stream or the river designation has any impact on it. But I'll phone a friend. Yeah, it's just navigable, non-navigable determines your right. So non-navigable, your property owner's rights extend to the center of the thread. So navigable is the low water mark. So typically, except in the situation where you have a grant from the Crown. And one of the things that I haven't been able to seek out is an actual grant from the Crown that grants exclusive rights to the fishing of the river. I haven't seen that. I am told that there is that it's out there, but I haven't seen that. And there is some debate as to whether or not you can even that the state could even grant that right. So I don't know if that helps. It probably doesn't.
Another follow-up question: the U.S. Constitution takings clause, state takings or damage clause. Has there been analysis on the impact of takings jurisprudence and the statute last year, as well as the revisions to it?
Currently, we have pending litigation that is claiming a taking. And this language in 21 and 22 specifically, I think, puts us in a better position than we were with 115.
Thank you.
All right. Chairman Smith.
Thank you, Mr. Chairman. Mr. Whip, thank you for working so hard on this. So I was thinking about what the effect this would have down there on that first line of defense against the state of Alabama out in West Georgia. Our family farm, we own not to the middle of the creek, but we own all the way over to the other side of the creek. And so what is that? What would this have an effect, like real world example there? How would you envision this going forward and somebody trying to float down that creek? Because part of it, I would say, I could get a little PO and float down part of it.
Well, it all hinges on whether or not whatever creek you're talking about is navigable or non-navigable. If it's been delineated as navigable, then regardless of where your ownership is, you can float down it. You can hunt it, you can fish it with regard to the Senate Bill 115 that we passed. And think about it from this perspective. With the litigation, I think the impetus of the bill was this: if you can shut down a navigable water, think about the navigable waters that we have all over the state, and if the precedent was allowed to stand, then our hunting community, our fishing community, and our paddlers wouldn't be able to utilize any of our rivers. And for a South Georgia legislator, I would have an uprising on my hands, and a lot of folks would around the state, because it is important for our folks to be able to access the rivers and streams of the state.
Thank you.
All right. Any further questions? Appears to be all that we have right now.
All right.
Thank you. At this time, we got another page. Oh. All right. I think I'll just start in the order I have it right here. Start with Joe Cook.
Thank you.
Thank you, Mr. Cook. If you would pull up the mic and introduce yourself and then give us your statement.
My name is Joe Cook. I'm with Georgia River Network, and I'm here to speak to this, and I dropped my statement there, picking up on my papers. Thank you for saving me. Since 2005, I've served as Georgia River Network's Paddle Georgia coordinator and guidebook author. Georgia River Network represents about 500 dues-paying members, and it's our belief that it is in the best interest of the state to ensure the public has the right to float down all streams capable of floating a vessel, not just streams capable of floating barges or boats loaded with freight. For that reason, we would offer the following additional language for this bill. Quote, the General Assembly finds that by common law there exists an easement for the passage of boats on all Georgia streams capable of supporting passage. You've already heard about kind of the intent of Senate Bill 115 and House Bill 1172, and we appreciate Representative Burchett, your hard work on this. And we generally we support the idea of navigable streams being open to the public for passage, hunting, and fishing. But the problem with the language in Senate Bill 115 and House Bill 1172 is that vast numbers of Georgia streams will fall under the category of non-navigable implicitly. And based on that 1863 definition of navigability, which nobody's heard that definition here in this meeting, so I'll read it. The term navigable stream means a stream which is capable of transporting boats loaded with freight in the regular course of trade, either for the whole or a part of the year. The mere rafting of timber or transporting of wood in small boats shall not make a stream navigable. So that definition dates to 1863 and no longer reflects how we use our rivers. Today, if you go out on a river, you might find one of more than 70 outfitters that are renting canoes and kayaks and other vessels on Georgia's rivers. But no matter how hard you look, you won't see any boats of any size moving freight on Georgia's rivers. So what we argue is that an easement exists on all of our streams that are capable of floating a vessel, and that easement exists regardless of who owns the stream bed. So on a navigable stream, they only own to the low water mark. On a non-navigable stream, the riparian property owner owns to the center line. But regardless of who owns the stream bed, we believe that an easement exists where people can pass in a boat. To give you some examples of how important it is for our streams to be open and accessible to the public, Georgia River Network each year organizes Paddle Georgia. It's a week-long canoe and kayak trip, the largest week-long canoe and kayak camping trip in the country. 250 to 400 people participate each year. We organize dozens of on-river events annually. Since 2005, our events have pumped millions of dollars into Georgia's economy, and many of our trips have taken place on rivers and streams that may not be deemed navigable. Some examples: the Yellow River, the Middle Oconee River, the Upper Etowah River, the Alapaha, the Tallapoosa, the Conasauga, the Ogeechee, the Coosawattee, and creeks like South Chickamauga, Spring, and Ebenezer. So moving forward, we think it makes sense to define where we have the right to pass on a navigable stream, but we also encourage you to recognize that there is a right of passage on all those streams that are not navigable.
Okay. All right, Whip Burchett.
Thank you, Mr. Chairman. Thank you for the testimony. One of the things that I do want to point out is that my bill does not prevent someone from floating, fishing, or hunting on a non-navigable stream if they have permission from the landowner.
Thank you. All right, next up is Suzanne Wielander.
Yeah, Wheelander.
Wielander, all right. All right. If you would introduce yourself and give us your statement.
Okay, terrific. I'm Suzanne Wielander. I'm the author of the Georgia River Guidebook that's been in publication for 50 years. I'm also here testifying in support of Georgia River Network's suggested amendment to this bill. On behalf of approximately 1 million paddlers who live in the state of Georgia, I'm urging you to protect the freedom to float in Georgia by ensuring that any stream, navigable and non-navigable, is capable of floating a boat and it remains open and accessible to the public. Recreational paddling in Georgia is mushrooming. For example, 38,000 Georgians now participate in actively in Kayak Georgia, which is a social media interest group that didn't even exist 4 years ago. There's also other groups that each have thousands of active participants: Middle Georgia Kayakers, North Georgia Kayaking, South Georgia's Walls River Coalition, and more. Paddling rivers is a wholesome activity for Georgia families who want to tear their kids away from screens and give their teenagers a thrilling experience that does not involve driving and drinking and drugs. And I'll always remember the South Georgia father who brought his daughter to an Alapahuchi River trip where she found the courage in herself to paddle a rapid solo. And I'm concerned that future generations might lose this ability to have those experiences, particularly on rivers as small as the Alapahuchi, which definitely wouldn't pass a navigable test. Recreational boating is also a huge revenue generator for Georgia's rural economy. Boating and fishing put $1.1 billion into our economy in 2022, according to the U.S. Bureau of Economic Analysis statistics. We are blessed in this state with world-class paddling experiences that bring paddlers from around the world and from colder states where everything freezes over in the winter. So all of that creates an outdoor recreation industry that provides 238,000 Georgia jobs and generates $1.8 billion in state and local tax revenues every year. Our rural cities and counties are investing their own tax revenue to develop water trails that welcome more paddling tourism to their areas. But some trails on small rivers are at risk of losing their rights to passage if this passes. I think of, in particular, the Kinchafuni and Muckley Creek water trails that are under development in South Georgia and Lee County. And again, I'm concerned that rivers of that size would not be considered navigable, and that private property owners could assert their rights to close those experiences down to people. So in my mind, the key question is, should private property owners on all of these streams have the power to override public freedoms and all the economic benefits that flow from them? And I just ask you to protect Georgia's freedom to float by ensuring that any stream, navigable and non-navigable, that's capable of floating a boat remains open and accessible to the public. Thank you.
I see no questions. Thank you.
Mm-hmm.
Carol Reiser, I hope I got that right.
Yes.
All right. Introduce yourself and tell us what you want us to hear.
All right. Thank you, Mr. Chairman and members of the committee, very much. My name is Carol Reiser Proctor. I did get married recently. And I'm a past president of the Georgia Canoeing Association. We are canoeing, kayaking, stand-up paddleboard, all types of watercraft. And we have about 500 active members, but our social media reach really is in the tens of thousands, as Suzanne was mentioning. We share a mission with American Whitewater, which I'm also here on behalf of. It's a national organization with a lot of members in Georgia, and our mission is to keep Georgia's rivers clean, flowing, and open to paddling. I particularly want to thank you, Representative Burchett, and all the people who are dealing with this issue of navigability. It's not, as you said, it's very complicated, and we do appreciate your struggling with that. The major issue that I wanted to address today is the navigability one, or non-navigability. We do believe it would be impossible for us on all of the rivers that we traditionally paddle to contact every paddler, every property owner, and ask for permission. But to protect property rights, if we have a passage through, the way we usually do, without getting out on their property, making any, damaging people's property, getting into fights, doing those sorts of things, our tradition is absolutely we pass through. We don't get out and party on people's property. So this has been addressed in North Carolina and South Carolina, where they also have significant boating and fishing revenues. They have taken this on to protect both the rights for paddle sports and private property owners by relying upon what they call a modern pleasure craft test to determine the extent of the public's right to paddle a stream. So in North Carolina, the Attorney General gave the opinion that citizens have the right to travel by, quote, useful vessels, such as canoes and kayaks, in the usual and ordinary mode on waters which are in their natural condition capable of such use without consent of the property owners. In South Carolina, the statute, like Georgia's, defines navigability for purposes of public trust based on the historical concept about the transportation of goods, which is in turn based on the concept of valuable floatage. They go on to say that valuable floatage includes people in pleasure craft. So you have the right of passage in that respect. Both states, however, say that you have the right of passage and nothing more. It does not expand it to being able to go on to people's property. So if the committee decides to issue a report that recommends an approach to describing which kinds of streams the public has a right to paddle, we strongly recommend that the committee follow the lead of these other neighboring states where they have found that this works very well. In closing, please protect Georgians' right to float by ensuring that all streams capable of floating boats are open and accessible to the public so that everyone is on the same page, the owners and the paddlers. And we will very much appreciate the resolution of that dispute. On a personal level, I'm one of the many thousands of citizens who deeply value my freedom to paddle on Georgia's rivers, and I don't want to have to go elsewhere for that freedom. So thank you so much. I appreciate that.
All right. Representative Kelly.
Thank you, Mr.
Yes,
Chairman.
certainly.
I appreciate your testimony today because I share your enthusiasm for floating down our waterways, and I'm trying to make sure I haven't broken the law previously when I've been doing it, because I generally do it up on the Kusawati where I have a little cabin.
Mm-hmm.
But the way I read the bill is we're only focusing on navigable waters, and we're kind of refining what can be done on navigable waters. But to me, the bill's silent on non-navigable waters. So that's where I'm really struggling with. How are we changing the law in this bill as it relates to non-navigable waters? Because I don't see like a thing there. No, so that's what I'm trying to get to here.
It's exactly right. It doesn't change it. It emphasizes navigable, and we're really asking that it be made clear that we have the right of passage through non-navigable, according to the 1863 definition as well, or something that would change the 1860 or clarify the 1863 definition to include a right of passage for people, not just barges and things.
So when I float down the Kusawati, like I did last summer, and about every summer I've done since I was about 5 years old, have I been illegally trespassing?
I don't believe that was considered a navigable water under this statute, but I would say that would be a matter that it would probably have to be, if somebody challenged you, would have to go into possibly in a court case. Typically, owners, if you don't get out, owners do not challenge you or get upset with you. But if you really want to go by that absolute right of definition of, is this a navigable river, and yeah, the property rights probably do extend to the center, and you could be trespassing, but if no one's challenging you, then people do that. But this would mean that we would be able to safely do that, and they would know, and we would know that this is okay as long as we're not getting out.
Okay.
So,
But we're not changing, we're not necessarily changing anything about non-navigability in this bill, correct?
I don't, Joe, is that correct? I don't see.
If I have permission to speak. The bill does not mention anything about non-navigable streams. It's implicit. If you define streams as navigable, then those that don't meet that standard of navigable then become non-navigable implicitly.
And that's what I was kind of looking at. The language we struck originally only referenced navigable streams, but then we kind of replaced what you could do on a navigable stream on lines 12 through 15. We just replace it with what you can do on navigable streams from 16 to 19, and then 21 through 23. And so I just kind of felt like we changed one use of navigable streams on one area of the section, and just moved it and tweaked the definition some. But that's where I'm trying to struggle with. So are we, what have we changed when it comes to non-navigable? Because I thought I just heard that maybe what I've been doing for 30 plus years is illegal, and maybe it's not. And I get maybe if we wanted clarity in that bill, but I don't think that the whip's changing anything as it relates to that in this bill. Is that a fair assessment? Okay, thank you.
Thank you. I believe that's all the questions.
Thank you so much.
Dan McIntyre.
Mr. Chairman,
Yes, sir.
ladies and gentlemen of the committee, I seek to answer your concern about your trip down to the Kusawati.
I'm getting nervous myself.
And I do it not on my own authority, but on the authority of Chief Justice Norman Fletcher, who is one of the premier jurisprudents of the state forever, I think. And he's widely respected. I have here an original signature and a copy for each of the members that I would like to tender into. That's Judge Fletcher's letters. And let me spend just a minute to do some highlights. He says, I'm writing today in support of efforts to secure Georgians' right of passage on the state's rivers and streams. The critical language there is right of passage. This is an entirely different concept than the navigability. Navigability determines who owns the river bottom. Right of passage is unrelated to that. Rite of passage is, as we will talk, as Justice Fletcher says, and as we'll mention a little later. He says, while Senate Bill 115 adopted the 2023 legislative session establishes citizens' rights to travel on navigable streams, that legislation before you today, HB 1172, leaves a vast category of streams in uncertain legal waters. And I'm very concerned that we have created, with this language of this bill, a negative implication there. If we declare navigable streams to be open, haven't we, by negative implication, said non-navigable streams are not? And that is our big concern in the paddling community about this bill. And here's Justice Fletcher's take on that. The definition of navigable streams was created in 1863 when the General Assembly appointed commissioners to prepare the original code of Georgia. The General Assembly instructed these commissioners to develop a code that embraced the existing law. They gave the Code Commission no authority to change the law. Yet, the argument is frequently made that the 1863 Code changed the law, which had been set forth in 1849 by the Georgia Supreme Court in the case of Young versus Harrison, which is this. There are three kinds of rivers. First, such as are wholly and absolutely private property. Second, such as are private property subject to the servitude of the public interest by passage upon them. The distinguishing test between these two, whether they are susceptible or not to use as a common passage. And third, rivers where the tide ebbs and flows, which are called arms of the sea. So the Georgia common law of 1849 declared that anything that would float your boat, you have a right of passage. And we believe that is still the law of Georgia and has always been the law of Georgia, and that the Code Commission of 1863 had no legal authority to change that. Justice Fletcher closes by saying, I urge you to use your power to protect and preserve this historic rite of passage on Georgia streams. The rite of passage is a concept which is totally independent of the navigation issue. Navigation is who owns the bottom, who can keep you from sitting on a rock in the middle of the river. That's not the rite of passage. The rite of passage is inherent in any stream that will float the boat. And it would be wonderful if Georgia could clarify that, like North Carolina and South Carolina have, and the same is true in Florida and Tennessee. We will be the only state in the Southeast that has restrictions on any stream that'll float your boat. If we, by negative implication, say only navigable streams are open to passage. Any questions? Thank you.
Tim Brenner. I don't guess we have a Tim Brenner here. George Virgo? I hope I said that right. I don't have my glasses on. Yeah.
Good afternoon. Thank you for allowing me to speak today. My name is George Virgo, and I'm the general manager of the Chattahoochee operations for the Nantahala Outdoor Center here in Atlanta. We're a watercraft rental operator for the National Park Service on the Chattahoochee River on the National Recreation Area. In addition to that, we also operate in 4 states in the Southeast and run adventure trips across the globe. At our summer peak, our business employs over 600 people, including 50 to 60 staff at our operations along the Hooch. Each year, our service enables 14,000 people or more to explore the Chattahoochee River. On average, 10% of those visitors are from out of state. We are at least one of 70 other outfitters that rents canoes, kayaks, stand-up paddleboards, and tubes, and other vessels to the public. Businesses like ours depend on Georgia's rivers and streams being open and accessible to the public. While this bill does not threaten our operations on the Chattahoochee, designating some streams as non-navigable based on Georgia's 1863 definition of navigable streams would give riparian property owners along those non-navigable streams the right to prevent passage through their property. This could threaten trips that we run on the Cartacay River and various other rivers in North Georgia, and it could threaten the routes upon which many other outfitters of this state depend. In our other states where we operate, North Carolina, South Carolina, and Tennessee, state laws protects paddlers' rights to pass through any stream that is capable of floating a vessel. These laws have worked to support a robust outdoor recreation and tourism economy in those states while also protecting private property rights. Georgia would do well to emulate these laws, and rather than enacting statutes that could greatly limit where recreational boaters have the right to paddle. We urge you to support Georgia's small businesses and protect the state's strong outdoor and recreation and tourism economy. Thank you for letting me speak today.
I don't see any questions. Thank you.
Thank you.
Janina Edwards.
Good afternoon. I'm Janina Edwards, and I'm an African-American writer and an American Canoe Association certified kayaking instructor. The ACA is one of the oldest nonprofits in the United States. Its policies and programs have been the gold standard for paddle sports for more than 100 years. The Georgia State Director and the Regional Chair were unable to attend today and asked me to appeal on their behalf. We have been working hard to expand access and diversity to our rivers and waterways. I am now one of 11 Black certified kayaking instructors in Metro Atlanta. I regularly take Black people onto Georgia's rivers and lakes. Black people and people of color are an active part of Georgia's outdoor community. We swim and kayak, tube down rivers, and enjoy stand-up paddleboard. Personally, I've kayaked everything from the Savannah, the Ogeechee, the Okefenokee Swamp, the Suwannee River, and the Flint River, which has been mentioned today. In addition to the rivers that cut through our urban communities, the Chattahoochee, the South River, and more. I mention this because I want you to understand that there are more Black people and people of color like me. We value our access to these waterways. We are deeply connected to this land and these waters as a people, whether we were born here or brought here. And as the outdoor industry has grown, so has the participation of people of color, through groups such as Outdoor Afro, Black to Nature, Chasing Waterfalls, and the Black Hiking Club, not to mention Georgia River Network and the outfitters in our state. Today, I ask that you clarify where Georgians have a right to boat, fish, and hunt as you legislate in the broadest terms possible. Your words can send an inviting message to the growing numbers of Black people and other people of color that participate in paddle sports and tourism, or you can flippantly limit our participation and potentially create a hostile environment for people of color who participate in paddle sports going down these rivers in South Georgia and other areas that don't always look so friendly to us. This is not just a message of racial peace and diversity. It's also a message to allow this segment of our economy to continue to grow across racial and cultural lines. As you move forward to define those seemingly small words, navigable streams, please think deeply and widely to ensure we don't cut off access to the life-affirming rivers and waterways for all of Georgia's citizens. Thank you.
I have a question for you.
Mm-hmm.
How do you interpret like fishing streams as far as navigability or what you want done with this law?
Yeah, so I was the other night, I was with Joe at a thing, and he's like, hey, we're going to speak at this thing. And I was like, oh, they should know that everybody, that I'm included in this group. And so some of those terms I honestly might not be able to define as intelligently as I should. But I know that what comes up on the river as you're going down there and you're on the waterways and you want to go this way or that way, it needs to be clear before I get in a boat and before I'm confronting a landowner or whomever as to what the rights are. So I'm not answering you directly because I don't know the answer, but I know that once I'm out there and it's just me and my boat and potentially a property owner, it needs to be clear. What I can get through on my little sea kayak and what a barge that's carrying logs or whatever are completely different things. I don't know if that helps you.
Yeah, not much, but yeah.
Sorry, I'll think about it. I'll think about a deeper answer.
And I understand. I hit you with that question because that's part of this. That's what makes this complicated.
Yeah, no, I get that.
We on the study committee learned how delicate these streams, the trout fishing streams, are, and the industry that they support right now. So it's not just the floating industry. We've got the fishing industry out there as well. So that's some of the questions that we look at when we put this bill together.
Yeah, it is hard.
Okay. Well, thank you.
Thank you.
I don't see any other questions. Ben LaChance.
Ben LaChance was not able to be here. I do have a statement if you would allow me to read it on his behalf.
Okay, why not come up? How long a statement is it?
It's short.
Okay.
This is a statement from Ben LaChance. For the last 43 years, my wife and I have owned an outfitting business which offers self-guided canoe and kayak trips on certain sections of the Chestatee and the Etowah rivers in North Georgia. Over those 43 years, the offering of these trips has attracted enough guests to create a significant positive economic impact on our local communities, as well as warrant establishing river accesses which are highly used and appreciated by the general public. The most popular trips pass through privately owned property where, in those 43 years, we have rarely encountered any concerns or issues raised by the property owners due to the fact that our guests float through their property boundaries. In addition, my wife's family, who owns significant river frontage in northeast Georgia for 7 generations, has never dealt with any notable trespassing or property damage issues by the people who regularly float through their properties. Therefore, even where potentially dangerous rapids require most paddlers to exit their boats and walk around the rapid, they've never put up no trespassing signs or fenced off the safer passageways. Thank you for the opportunity to speak to this committee on behalf of the large community of people who enjoy being able to get away and float a beautiful creek or river. Ben and Dana LaChance of Appalachian Outfitters.
Thank you. I believe I know Dana. Went to college with her, actually. All right. Let's see. Mike Worley.
Thank you, Mr. Chairman, for the opportunity to speak to you. Thank you, committee. It's been a real pleasure to see you. And Chairman Burchett, I know that I continue to refer to you as Chairman Burchett because you did a magnificent job of running that study committee as chairman, and I appreciate the hard work and the effort and the time commitment and all the other stuff that goes into it. For being new to some of these issues, you have demonstrated a remarkable grasp of those issues, and I appreciate that. As we've talked almost a year ago, Governor Kemp and you as the General Assembly saw a threat to our hunting and fishing traditions and did something about it. You passed Senate Bill 115. For generations of Georgians and generations of people on this land before it was Georgia have commonly passed our navigable streams and have fished and hunted those navigable streams. In very recent times, some landowners asserted they could exclude anglers from those streams, and some of those landowners even asserted they could charge people to fish on those streams. You, in your collective wisdom of our General Assembly, agreed that our common laws favored the customs of our forebears
and you passed Senate Bill 115 to restate that common custom and clarify that common right. Governor Kemp signed that into bill into law, and it became effective on July 1st, 2023. Today, and for the past 7+ months, hunters and anglers have enjoyed the rights that they have always enjoyed, and chaos has not ensued in our waters and streams. I think you even pointed that out, Mr. Chairman. The House Study Committee on Fishing Access on Freshwater Resources established by y'all prior to the passage of Senate Bill 115 decided to focus their majority of their efforts on that bill. Finding number 3 of the committee's report recommends you maintain the underlying purpose of Senate Bill 115 while removing references to the public trust doctrine in statute in recognition of the doctrine's standing as a common law provision. I appreciate the changes. As House Bill 1172, as introduced, I fear did not follow those findings of number 3. It prohibited hunters and anglers from contacting beds of navigable streams, and as someone who has fished Georgia's waters from my earliest memories, one can hardly fish our streams without touching the bottom, and the same goes for hunting. We appreciate the changes that have been made in this substitute. Thank you for considering those changes that seek to recognize our traditions of hunting and fishing, and I've changed my notes a bit as we've had this conversation today, and it continues to maintain Senate Bill 115's underlying purpose. We must ensure, and I appreciate the words that you used, Chairman Burchett. We must ensure the legislation continues to allow all traditional uses and activities of hunting, fishing, and passage. And I enjoyed Chairman Burchett's assurance that they do. The wisdom of Senate Bill 115 that this body codified with the partnership and leadership of Governor Kemp is remarkable. We believe it is valuable, and means that we can continue those traditions. Further codification requires that we're vigilant that the interests of hunters and anglers are protected. I look forward to working with you. I support the changes that have been made, and we look forward to continuing to ensure, as all of you, I think, as we've heard throughout all of these meetings, that hunting and fishing are protected here in the state of Georgia. Thank you, Mr. Chairman.
All right, Mr. Worley. Representative Evans.
Thank you, Mr. Chairman. I just missed who you were with, who you're speaking on behalf of.
I'm sorry. I sat down and just started talking. My name is Mike Worley. I'm with Georgia Wildlife Federation. Georgia Wildlife Federation is the state's oldest and largest member-supported conservation organization. We were founded in 1936 in Macon, Georgia, and we still have the same mission statement from those days. We were founded by hunting and fishing clubs in those days, and we have certainly grown our tent considerably since those days.
Good work. Do you support, I wanted to make sure, like, if your preference, if you were king for the day, would you rather just leave it alone, or do you see a real need for the language in House Bill 1172, and if so, why?
If I were king for a day, looking at the committee's report, I would accept that report. I would probably have just taken the words public trust doctrine out of Senate Bill 115, and that would have been the change.
Called it a day.
Called it a day.
Thank you.
Seems a remarkable amount of work to accomplish the same thing.
Thank you.
I believe that's all the questions. Thank you.
Thank you, Mr. Chairman, and thank you, Mr. Chairman.
Tom Wielander or Wellander? I'm not sure which.
It's Wielander.
Wielander. Got it right. All right.
Hello, members of the committee. Thanks for hearing my testimony. I come to you as a citizen. My name is Tom Wielander. I live in Atlanta, and I'm here because I'm worried the proposed legislation would wreck my pastime. I'm a recreational canoeist. I love living in Georgia because we have outstanding rivers in the mountains. in the Piedmont and on the coastal plain. We have excellent rainfall. We have a great climate. I want Georgia to have the same rites of passage that our neighboring states do. From my experience, those laws are working very well in North Carolina and South Carolina and would serve us well. They respect property rights, and they respect that the rivers, the waters in the state of Georgia belong to the citizens of Georgia, if we were to adopt that same type of language in our rules. Small streams are really important to me. They're a special breed apart from the larger streams we consider, air quotes, navigable. They're intimate, they're narrow, they're convoluted, they're often canopied by big old trees. It's a phenomenal experience, and it requires a certain amount of skill that I've developed as a canoeist, and so it's rewarding in that regard too. My next point is I don't trespass, and the companions, the 2 or 3 people I do this with at any given time, we know that private property is private property. We know that the stream beds are private property. We don't violate that if at all possible. Mishaps do happen sometime, but we respect property rights, at least in our mind. If a DNR officer disagreed with me, I would defer. I want to testify that I have not personally had any negative encounters with streamside property owners in 25 years of paddling Georgia rivers. We frequently see people at fishing shacks, at whether it's down on the Ahoopi where they're standing up on big poles, or in the mountains. As we float by in our canoes, we wave and smile. They invariably wave, smile, and wave back. So I'm not speaking for those people, but in my personal experience, I think that the objection comes from a narrow faction. I hear Representative Burchett's assurances that navigable rivers will be protected, will not be restricted. So I looked, I'm a citizen, I got schooled in this subject by looking at the dictionary definition of navigability. That doesn't look anything like Georgia's definition of navigability. So what are you talking about?
It's up to you.
Navigability says it can float a boat. And are you wanting the citizens? Sorry, go ahead.
So there is a difference between the Webster definition and the legal definition of navigability. So to put it delicately, the definition of Webster, it doesn't hold any legal bounds over what's navigable in the state of Georgia. It's only what is in statute, and so that's what we're following, is what is navigable. And to that point, we haven't changed the definition of navigable. It's been what it is since, I think, 1863. There's been a good bit of conversation about the rite of passage, and if you look in our recommendations in number 5, to ensure the protection of rite of passage for navigable streams as found in OCGA 52-131. It's already codified. If you read that code section, we have restricted the rite of passage to navigable waters. So as long as you're on navigable waters, what is deemed to be navigable, then you're not trespassing. You're floating perfectly fine, passage is fine, hunting is fine, fishing is fine. If you get into a scenario when you're on a non-navigable stream, as per the definition in statute, then you could be trespassing if you don't have permission of the landowner. So like you, I float down a black water stream in South Georgia that you'd be hard pressed to put some freight on. It is deemed navigable, but there is a gentleman there that's purchased property up a creek, tributary coming into that river, who has, unilaterally said, I own both sides of the river, and he's shut off access to the 17-mile creek, which is some of the best redbreast fishing in the state of Georgia. So much to my chagrin, I cannot go up there because it is a non-navigable stream. And I don't have the right of passage on non-navigable streams.
Mm-hmm.
I don't have the right to hunt. I don't have the right to fish. According to our statutes currently, you don't have the right to pass, hunt, or fish in a non-navigable stream. What it sounds like you're advocating for is expansion of the right of passage. Now, that's another conversation for another day. I don't believe that falls within the bounds of my bill, but I hope that answered the question.
Thank you, sir. I understand that by taking the words public trust out, it would have exactly that effect. Am I wrong?
Exactly what effect?
Of depriving my access to smaller streams.
So Senate Bill 115 gave you no access to non-navigable waters
Mm-hmm.
whatsoever. It was specific to navigable streams.
Mm-hmm.
And so there was never an expansion of the right to go into a non-navigable waterway. That doesn't mean you can't go. Many people float, fish, and hunt on non-navigable streams because the property owner gives permission or does not want to exclude you from doing it.
Mm-hmm.
Does that help?
Thank you, sir.
Yes, sir.
Yeah. And one more point, if I may, is I just want to say from the point of view of an unschooled citizen, I understand that the water in the rivers belongs to the citizens of Georgia. I understand that the stream beds belong to the private landowners. I see that the state appears to be giving privilege to property owners to use the water to farm fish and to sell the rights to come fish on that water. And so it seems ironic from my point of view that public who own the water would be required to give that use to those property owners and be deprived of access to that water. That's probably not what you're thinking, but that's how I perceive it as a citizen who doesn't know the law, but wants to respect the law.
Okay.
Thank you.
Thank you. All right, let's see. Adam Bellflower.
Good afternoon, Mr. Chairman and committee. Wanted to come speak on behalf of Georgia Farm Bureau. I work for Georgia Farm Bureau. We are the general farm organization in the state of Georgia. We represent about 40,000 farmers across the state that farm in every county and all commodities from corn to blueberries to cattle. So we were one of the organizations that had grave concern with the passage of Senate Bill 115. We were very concerned with the introduction of the public trust doctrine as it applies to navigable waterways in the state of Georgia, and our members were very concerned with that as well. They really voiced their concern throughout this off season by using the study committee that Whit Burchett chaired, and we appreciate the work he did there. We are in support of House Bill 1172 and the measures that Whit Burchett has laid out. We believe he has done an excellent job with this bill. It alleviates our concerns of the public trust doctrine. And to speak to the representative's point, we as an organization do believe that it is necessary to strike for the entire strike of what's in lines 12 through 15 to completely alleviate the reference to the public trust doctrine, and we do believe that falls within the purview of the study committee's recommendation. So we appreciate the work Whit Burchett did on that, and then we also recognize the efforts of Senate Bill 115 to allow and to reiterate the right of passage, hunting and fishing to navigable waters. So therefore, again, why we support this bill, and we appreciate the way that Whit Burchett went about that, not by utilizing the public trust doctrine, but instead by explicitly stating the rights to which he wants to grant to citizens. We also support the exclusive right of private property owners on non-navigable streams. We believe that is crucially important to the state and to our farmers. So that is it then.
All right.
Willing to answer any questions?
All right. Representative Evans.
Thank you, Mr. Chairman, and thank you for your testimony.
Yes, ma'am.
Could you, for those of us that were not part of the study committee meetings, who, for instance, what kind of members were concerned about this, and specifically what is or was the concern about the public trust doctrine language that made folks so nervous? And I guess more directly, perhaps, you can answer that generally, but my more direct question is, what is it that your members don't want other people in Georgia to be able to do that they think they would be able to do under 115?
Yes, ma'am. That's a great question. And this is something that a lot of, and I think some of the people that are going to follow me have similar concerns to this, so I'll speak to this. What we have seen in other states that have public trust doctrine applied to navigable waters is we have seen that as a way to sue permit holders. So all of our farmers they have to obtain an agricultural water withdrawal permit if they irrigate or if they pump over 100,000 gallons of water per day. They must obtain this agricultural water withdrawal permit. And what we have seen in other states around the nation, and I can provide you with some examples of this, is where people that are in opposition of farmers utilizing these permits would bring a lawsuit against a farmer by saying that their use of this permit negatively impacts the resource, which is held in trust by the public. So in reference to this bill, to the irrigation, a good example of that would be down on the Flint River, where EPD has done extensive studying and shown that irrigation can, in fact, impact flow rates of the Flint River. One of our concerns is that by applying public trust doctrine to navigable waterways, that someone who was not in favor of a farmer irrigating, that they could say that your irrigation permit is affecting the Flint River. Therefore, they could come after that farmer for permitting for their permit, and they could come after, most importantly, the state of Georgia for issuing that permit that negatively impacts what they say negatively impacts the flow rates of the Flint River, even if the farmer is operating within the bounds of their permit. Does that help clarify?
Yes. Has it happened?
To directly in Georgia, no, ma'am. Where there has been instances in other states where, and this is something I can provide you with, there has been instances in other states where a permit holder was operating within the bounds of their permit and they were sued, and the public trust doctrine was cited in suing that permit user.
How many times and where? And is it ongoing?
One of those cases in North Carolina. The most recent case that we were looking at was in North Carolina, and it had to do with a fishing permit.
Is it resolved, or is it still pending?
I would have to check. I have not recently checked, so I'm not confident enough to answer that question.
Any other examples?
I can provide those to you later on. I'm not going to try to bring those up off memory right now.
Okay. Thank you.
Yes, ma'am. Thank you for your question.
Whit Burchett, did you have anything? Okay. Thank you.
Yes, sir. Thank y'all.
Let's see. Here we go. Jake Matthews.
Good afternoon, Mr. Chairman, members of the committee. Thank you all for letting me be here with you this morning, or this afternoon, sorry. I'll just reiterate, thank you, Whit Burchett. Thank you to the chairman for y'all's work here today on this, and really to the whole study committee that looked at the issue. I mean, a lot of work was put into it, and we greatly appreciate it. My name is Jake Matthews. I'm with the Georgia Forestry Association. We represent just the whole forestry sector all throughout the state. Everything from landowners to foresters to any kind of manufacturing dealing in the forestry industry. So a diverse membership that this issue in particular means a great deal to. We just wanted to get up here today and express support for what's been done in this bill and the changes that were made to address those concerns that came up as a result of the study committee. And we look forward to working with you as it continues to go forward throughout the process. But I'll keep it short and leave it at that.
Okay. Representative Evans.
Thank you, Mr. Chairman. Thank you for your testimony. Similar question to what I had for the Georgia Farm Bureau representative, which was a water example. And since you're here on behalf of the trees, can you tell me what, if any, concerns your members have? What kind of members are we talking about? What are their concerns about what people are trying to do that they don't want them to be able to do?
Absolutely. So very similar to what my friend at Farm Bureau brought up. It has to do on the permitting side from any kind of manufacturing standpoint, but then also I think it was clearly seen in the study committee that a lot of concerns came up about private property rights and where that line was on what was trespassing, what was not, who owns what, and those were really our top concerns. And I think that the recommendations from the study committee addressed them really well and very clearly. So those are really our top two, very similar to what Farm Bureau has brought up here.
Can you give me for instance, an example? Because I'm not following. I mean, I understand
Yeah.
private property owners don't want people coming and camping perhaps on the side, but you're talking about permitting. Give me a specific, for instance, and if it's happened in another state, that's fine, but I'm really struggling to find the problem, and I'm hoping you can help me.
Certainly. I mean, kind of as he mentioned, water withdrawal permitting would be one of those things. Water is used in certain manufacturing within the forestry sector, and that would be one of those things. And kind of along the same line of thinking that he laid out, what we've seen in other states with the use of the public trust doctrine as a means to go after that in a way that kind of circumvents our current regulatory process.
Thank you.
Yeah, thank you.
I believe that's it. Thank you.
Thank you.
Jake Tench.
Thank you, Mr. Chairman. And if am I last on the list? If I am, I just don't want to be the last person standing between y'all and doing the great state of Georgia's business and these two fine gentlemen from presenting their bill. But my name is Jake Tench. I'm with the Georgia Agribusiness Council, and we are a trade association that represents over 1,300 members that kind of span across the swath of the entire agricultural industry, anything from farmers to manufacturers and anything in between. I just want to say thank you for allowing me to speak today. Upon the passage of Senate Bill 115, which has been referred to a lot today and why we're all here, we saw that as, whether it was the intent or not the intent, we saw that as a vast or a drastic change to the state's water rights, to the property rights, to the public trust doctrine. Although it is in common law, codifying it, laying it out, we felt that it opened up not only landowners, property owners, people that own property on the waterways, but also the state, and having to care for those resources and being responsible for all of those resources and maintaining that, whether it be through the permitting process that has been mentioned earlier. But I just want to thank all of you. Thank Whip Burchett for working with us. Thank you for all of those in this room that served on the study committee, from hearing our concerns. We are committed to working with you as this process moves forward, and I just wanted to sit up here and say that we support trying to get back to something that we can all live with and it be fair and reasonable for both private property owners and sportsmen in this state. We look forward to working with you, and thank you for having me today.
Representative Evans.
Thank you. I just didn't want you to feel left out.
Yeah.
Same question that I had for the last two presenters. Any specific examples of specific members with specific concerns or specific permitting issues that you could point me to either here in another state that led to your wanting to come here and advocate for this bill today?
Yes. So I'm going to try to refrain from specific members just because.
Or types. Yeah, you don't have to name them.
Right.
Yeah.
Farm Bureau mentioned the case in North Carolina that cited the public trust doctrine on a fishing permit, and this was deemed as a fishing bill. And when they cite the public trust doctrine, we see it opens not only those permit holders to litigation, but also the state. If the state is responsible under the public trust doctrine for those resources and for issuing those permits, whether it's water withdrawal, fishing, whether cattle have an opportunity to drink out of certain surface waters, those types of things can be construed or used. The public trust doctrine can be used as a pathway to go after those individuals, and not only those individuals, but we see it as opening up the state to possible litigation as well.
the cattle drinking the water, public trust doctrine, public access, I would imagine, I mean, in my simple
Right.
mind, applies to the farmer and his cattle just as much as it does to the paddler. So can you give me an example where someone has been cited or in trouble for letting their cattle drink out of a navigable stream?
Not a particular instance, but this bill has only been in play, or the public trust doctrine has only been codified for a year.
What about other states?
On that particular issue, I don't know of any, but I can definitely find out. And whether they're doing it on the navigable waterway or a tributary, and they can be seen while someone is paddling on a navigable waterway or whatever they're doing. If they don't, it's all subjective of what my ability to enjoy a resource. If I think that seeing something or smelling something or whatever is inhibiting my ability to enjoy that resource, that is where the public trust doctrine on our feeling comes into play, and they have that avenue.
Thank you.
Mm-hmm.
I believe that's all the questions. Thank you.
Thank you. Thank you all.
I also believe that's all the witnesses that I have signed up. Did I miss anybody? All right. Okay. Yep. All right. Any discussion by the committee? Representative Evans.
Thank you. And really more a question, if it's okay, Mr. Chairman, to Whit Burchett. Is there a special, has the state waived sovereign immunity with regard to something that would come under the public trust doctrine? Are we really worried about the state getting sued is my question.
That's a good question. I don't think we've waived any sovereign immunity, Representative Evans, but I do think that we have industries in my part of the world, paper companies that are drawing water out of the river that are worried that the public trust language would open them up to litigation for drawing out of the river. Now, I'll be just straight with you. I think they can bring those cases anyways because it's a common law doctrine. Mm-hmm. But our folks, these industry folks are worried that the addition of the language of public trust is going to tilt the scales against them.
Because we're not doing, I mean, trespass, nuisance, all these things are still going to exist.
That's correct.
And so then I guess my last question, and thank you, Mr. Chairman, for indulging me. If the issue was just public trust doctrine, I think somebody brought this up, my good friend over here, why didn't we just get rid of that? And why are we doing all this other stuff in the bill?
Well, it's, that's what we do up here. We perfect legislation, right?
Or we cause problems, one or the other.
So, along with the other recommendations, we sought to address the fact that there was no clarity in the bill to just say, nothing in this bill says you can get out on the bank. So that was the addition there. And really the rest of it is just rearranging, but if you can point me to a specific line that you're talking about, 17 through 18 and 19 is basically recital of the common law, which is just another word for public trust doctrine. I mean several words, excuse me.
Well, I think my concern with the extra language is, number one, it doesn't. I haven't heard anybody ask for it. The concern I've heard from the industry speakers was about the public trust doctrine. So I don't know why we couldn't just do that and call it a day. I think we've used words in line 17 through 22 specifically that also appear over here, and we know our good judges. If we used it twice, why did we do that? Are we trying to say something different? They're going to try to make sure that they can read the bill to give meaning to every word instead of having it be just extra surplusage, like whatever the word is. So that's my concern. But my bigger question is just, I guess, why do you need it? I would just put it back to you.
Why do I need it?
Yeah.
Well, for me, what this does is puts the state in a better position when it comes to a takings claim. So both of these pieces of litigation are claiming a taking. And I think with this legislation, we're in a better spot than we were with the Senate Bill 115.
Are you talking about the North Carolina litigation?
No, litigation in our state. That's the litigation that started this whole Senate Bill 115.
Okay. There's two pieces, you said?
There's two pieces, yes.
Well, then I'm going to stop because I will keep having questions. But I guess aren't we supposed to not work on bills that affect pending litigation?
Correct.
We already did.
Yeah, we already did that. It was Senate Bill 115.
So do we want to keep doing bad because we did bad already?
Well, I'm trying to put us in a better spot, Representative.
Thank you.
Representative Kelly.
Thank you, Mr. Chairman. I think if we were going to move on, continue moving with discussion, I was just going to make a motion to pass, and let's get to the discussion phase.
I have a motion. Is there a second? All right. Any further discussion? Any amendments? Hearing none. All those in favor say aye.
Aye.
All those opposed? No. Just raise your hand. For the ayes. All right. Those opposed?
It's tie vote.
All right. We got a tie.
No pressure.
No pressure. All right. I vote with the yeas. So the bill passes.
Thank you, Mr. Chairman. Thank you, committee members.
This is just the first step in the process. There's more to go. All right. All right. Let's see. Next bill up will be House Resolution 780. Having not been, for these folks, not been on the.
Come on, young man. I've waited this long. I'm letting the blood run to my feet. Oh. Actually, I'll use this one. Hey, buddy. Glad you're here.
Okay.
All right, you ready, Mr. Chairman?
Yes, sir. Go ahead.
Thank you, Mr. Chairman. And to the committee, I bring you today House Resolution 780. That is LC 472633. Should have before you there. And I've got several individuals that are going to speak today, to including the Secretary of State. And we also have a group from the an organization here that's very interested in speaking as well. But let me begin by saying I hope this is a very simple issue. Here's what we know at the outset, and I've got data here I think one of the organizations is going to speak to. When you look at polls, almost everyone of every demographic, of every party, in overwhelming numbers supports the fact that only citizens of the United States should vote in our elections in the United States. Almost everyone, and I've got the polling with me. Not going to bore you with that, and I promise I'm not going to talk about navigable waterways. That's for sure. But I have that data with me, and it's just amazing. It's one of the few things you'll see that polls, doesn't matter race, doesn't matter party, doesn't matter urban, rural, almost everyone supports this. And so we have an issue, and the issue is this, is that when you look at, we have a Georgia statute that requires that only citizens can vote in the state of Georgia. And we all know how statutes can change. We also have in our Constitution, in Section 1, Article 2, Section 1 of our state Constitution, we have language that was certainly intended to say the same thing, and some would say still does. However, we have a major concern that the language, if you look at it in a very textualist way, as certainly our Supreme Court does, that the language is very weak. And so if you look on line 8, the current language says every person who is a citizen of the United States and residents of Georgia as defined by law who are at least 18 years of age and not disenfranchised by this article. And it goes on to say, shall be entitled to vote. Our experts and legislative counsel that I've met with, other experts, and certainly our Secretary of State who wants to speak to this, believe that that language is not adequate to prevail against what is going on in other states. And let me just diverge for a minute to tell you about that. So in New York City today, and that's currently being dealt with, and I've got a legal pushback there at the moment, but Boston, New York City, Washington, D.C., San Francisco, Oakland, Maryland, a multitude of states in Maryland, and a multitude of states in Vermont are now allowing their non-citizens in those states to vote in local elections. Okay, and it is because they don't have strong enough provisions in their Constitution, or it's because they have a Constitution that doesn't address this. So clearly the goal here is to make sure that in Georgia we continue to make it very clear and that the text is clear that only citizens should vote in Georgia elections, in all Georgia elections. Now, so here's what, and the Secretary can speak for himself, and but here's what others like those that I've dealt with on this matter in legislative council believe. The language that is currently in place when it says every person, we've changed it to only individuals who are citizens. So the language today doesn't prohibit, and the new language clearly prohibits. And so the belief is that that is what it would take to withstand, a suit related to this issue in the Constitution. And so that is the goal of this. There's other things I can say, but y'all been here a long time. Obviously, what I'm trying to do here is take language that is currently very clear in statute and put it in the Constitution so it's very clear. I've mentioned what you're changing is every person to only individuals. And so we're clearly defining who is eligible to vote and who is not, which is what is currently in code. And so we're clearly here excluding those who are not citizens of the United States. It's exclusive. And so, I do want to mention one other thing I have a note here about. So there have been, in 2016 in Clarkston here, up near Atlanta here, there was a consideration of non-citizen voting. And again, it didn't progress beyond that I'm aware of. But again, these are the kind of conversations that are going to continue in the future, especially at a time when we have currently an open border problem in this country. So we have a huge influx of those that are non-citizens into the country. And so it's time that we deal with this, I think. And that's what this measure is designed to do. I did want to mention that clearly I want to be very forthright in saying when we put it in the Constitution, we make it harder to change in the future. And so I want to make it clear, and I think most Georgians, again, polling is right here, want to do just the same. I want to mention one other thing. There's a current a federal court case going to trial that that hopefully the Secretary can speak to, which is Georgia Coalition for the People's Agenda v. Raffensperger. And that issue is a suit against the state to end citizenship verification. So these are issues that are relevant today, whether we recognize it or not, and I think it's time that we do what the overwhelming majorities of every demographic in our state would like to do, is just make it very clear that only citizens of the United States should be voting in Georgia elections. Mr. Chairman, that's really what I'm trying to do here, and again, there are others that may want to speak to that, but I'm glad to answer any questions first as needed.
All right. Representative Evans.
Thank you, Mr. Chairman. Thank you, Mr. Chairman.
Yes, ma'am. Thank you, Representative.
Has anybody ever attempted to use the current language of the Constitution to claim a right to vote on behalf of a non-citizen?
I don't know that. I think perhaps the Secretary, could you address that in a moment to that question?
I'll save it.
Better if you don't mind. Yeah.
Well, let me ask you this, though, since you brought this on your own volition.
I did.
did someone come to you and say, hey, this non-citizen is trying to vote and it's because we have bad language in the Constitution?
No, it wasn't about an individual case. I think the concern is, my attention was raised by the fact that, and I mentioned a good number of these, so we have a multitude of states. I mean, I just listed, 5 or 6 right there that are already allowing non-citizens to vote in local elections. So that's my concern is, does that trend continue?
Where
I think
is that
I think it
happening?
well may.
Where is that, the local elections?
Vermont, multitude of states, you can Google that. Vermont, Maryland, California, Washington, D.C., by the way, allows non-citizens to vote. New York and Boston, so Massachusetts. So they tend to be very urban locations or in the cities. But actually, if you look in Vermont and Maryland, you'll see a lot of smaller towns that are allowing non-citizens to vote. And again, the question before us is, should we allow that in Georgia, or should we stand by what clearly was the intention here? We know that was the intention of the current Constitution, but the concern is that the language is very weak and may not, I'll use the term may not prevail. But thank you for the good question.
Whit Burchett.
Thank you, Mr. Chairman. Thank you, Chairman Petrie, for bringing the bill. So, do you think we should wait in Georgia until non-citizens are voting to act, or should we go ahead and act?
Well, I would think we should, we preempt a lot of things here, especially when you have, it's amazing to me when I started, and actually I was educated by some of the gentlemen, there's a number of gentlemen here on the back that are going to speak from the Frederick Douglass Society that educated me on the polling numbers, and they're going to speak to that. But when you have an issue that polls, it's rare that we deal with an issue up here where almost everyone agrees. And so to me, it seems like we should get in front of this and make it clear that it's very simple. If you're voting in Georgia, we're not worried about federal elections because we have a federal constitution that makes that clear. Mm-hmm. We're not even worried about state elections. But if you disagree, that's fine too. I respect everybody's opinion. But if you're voting in Georgia, we have to protect the sanctity of the vote. If you're voting in Georgia, you're a U.S. citizen.
Very good. And
Very
so
simple.
you've seen a trend in other states where this is being abused, correct?
There's clearly a trend for that, sir. Yes, sir.
And you just want to prevent that here in the state of Georgia, correct?
That's correct.
So this is another measure to secure our election and also to make sure that folks are confident in our elections. Is that true?
I think that's correct going forward. I want to make it clear to Representative Evans' good question. I'm not suggesting this has been abused in any way, shape, or form. This is about preempting an issue that we know clearly is happening in other states because they're legal. They're making it. It either is legal to allow non-citizens to vote, or, and by the way, this isn't about anybody. It's about non-citizens. Period.
That's correct.
It's about. It doesn't matter. The status, if you're either a citizen or you aren't, to keep it very simple.
Very good.
Yes, sir.
This is good due diligence. I appreciate you bringing the
Thank
bill.
you, Mr. Whip.
I believe that's all the questions we have.
Thank you, Mr. Chairman. And if I could now, I'll hand it over to Mr. Secretary.
All right. Welcome.
Welcome. Well, thank you, Chairman and Chairman.
Go ahead.
Well, good afternoon. I appreciate this opportunity to come before you. I support this resolution. I believe it's a solid resolution, and I think it's well needed. First of all, I believe that only American citizens should be voting in our elections. And I think that the chairman that just spoke for the bill made so many good reasons for it. Number one is that the Constitution does not specify that what about non-citizens, so it's not clear on that matter. And I think it should be very clear what the matter is, and I believe it should be that only American citizens. People can talk about the polling numbers, and there is that comes to play somewhat, but also you have to look at what really makes sense, logically what makes sense, because there's an element to that I think some people may be overlooking. Number one is, last I checked, if you want to be on a jury in America, you have to be an American citizen. So people have lawful resident alien status. They do not serve on juries. because they have to be an American citizen. And I would submit to you that it's far more important that your priceless franchise to vote, that people have fought for and died for this country, and have fought for the franchise through the civil rights movement, they understand that precious element, the franchise to vote. So I raise that even above the jury. And if you have to be an American citizen to be on the jury pool, it surely makes sense, logical sense, that you have to be an American citizen to vote. Then from a practical matter, if non-citizens were on the voter rolls, there's two elements that concern me with this. Number one, what about the voter list? Now you have non-citizens on the voter list, but you say, well, okay, we're going to allow them to vote in a city election. And that's how it typically has started throughout the country. But then how do you then say, well, you can't vote in the state election? How does a county election office maintain two different voter rolls? The complexity that you add to a very complex, process that we have already, it could possibly lead then to a non-citizen getting on a state election, a federal election. And if a non-citizen, then this is the next concern that everyone should have, is if a non-citizen actually votes in a federal election and is found for that. And this is happening right now. And then when they go through their resident alien process and they show up to get their citizenship, they actually have a felony. And that is going to preclude them from becoming an American citizen. And that's one of the things that these immigration judges are looking at through that process. In fact, the Secretary of State in Pennsylvania was recently at a conference and he talked about that. And so we want to make sure that people, while they're here and going through the lawful immigration process, don't do anything to jeopardize their future citizenship. Because I think that most people come to America because they realize it's a great country. It's the best country, I think, in the whole wide world. And I hope you share that opinion. And I think most people that go through that lawful process don't just want to be a resident alien for the rest of their life, that they do want to become an American citizen. It's really the gold standard. And so I think from the practical matter, but at the end of the day, I think it gets down to, what perhaps I think our founders would have believed. And that this was people founded that really were vested in the system. And the people that really vested in the system, the ultimate investment is when you're an American citizen. You're saying, I'm sticking my stake in here. This is where my future is. This is my country. And with that comes the additional benefit, the additional enjoyment that you enjoy the franchise to vote. The most precious right anyone could have is being an American citizen to vote in our elections. The chairman did speak about the lawsuit that we have right now from the Georgia Coalition for the People's Agenda. And they're actually suing, our office through the Department of Driver Services to preclude us from doing citizenship verification. We think that's really important. We actually went through the whole voter roll process of over 7.5 million voters about 1.5 years, 2 years ago. And what we found were about 1,600 voters that we could not identify. DDS had flagged them that they weren't American citizens, and so they were never put on the voter rolls. But the concern was, why did they try to apply? And is there a process there, or was it actually groups that try and just register people, not asking that and verifying that before they got there? But what we want to do is make sure that only American citizens vote. And right now, through that lawsuit, we would be precluded from doing that. And I think that the will of the large majority, as the gentleman said, large majority of both political parties, is very interesting to see what the polling is. 70% plus of both people in both parties, large majorities, believe that only Americans should vote. In fact, one poll even said 56% of all progressives thought only American citizens should vote. That's very interesting. With me today is Charlene McGowan. She is our general counsel. Also spent several years with the Attorney General's office and then represented them on the state election board. But, she deals with these election issues and the litigation. So if you want to ask me all those really difficult lawyer questions, this engineer would defer to my general counsel.
Well, you may have a lawyer question coming up. Representative Evans.
Thank you, Mr. Chairman. Mr. Secretary, thank you for being here. We miss you on the House floor.
Thank you.
My question is the one I posed to Chairman Petrie is, do we have any examples that have caused us concern in Georgia, either individuals who are non-citizens trying to vote, saying that the Constitution allows them to, or any local governments who have tried to allow non-citizens to vote? That's one question. And secondly, is there anything about the constitutional language in Maryland, California, D.C., New York, Massachusetts, or Vermont, which are the states that Chairman Petrie said are having the issues with the localities letting non-citizens vote. Is this language that you're proposing that we change to different than what they have? Is that why? Is that where you're seeking the comfort, because that you're seeking constitutional language that's different than theirs?
Well, to your first question, none that we're aware of about people or areas trying to allow non-citizens to vote. Though the Chairman Petrie did reference the city of Clarkston, which had floated that as a trial balloon, and I guess bit a hasty retreat when it was not received well by the General Assembly back in 2016, 2017. To the other issue, I would defer to my general counsel, or we'd have to just go through that and then actually get the word-for-word comparison so you could take a look at that. I don't know if Charlene would has an answer right now, or if we would need to go back and we'll get that to you. Do you want to come over here and speak?
Grab that.
Yeah, I think to get that level of detail, we would have to get back with you on the specific language that each of those states
Sure.
uses.
Well, I think listen, I think that only citizens should vote. I mean, we are in agreement on that. But if that is a true concern of the Secretary of State's office, if it's a true concern of Chairman Petrie or the majority, it seems like we should compare the language that you're trying to put into the Constitution through House Resolution 780 and make sure, by God, that it's different than what is in these other states, Vermont, Maryland, California, D.C., New York, Massachusetts, where you say this is happening. Because if we're putting language in our Constitution that's the same as theirs, then you really haven't done anything to squash your concern.
Well, the wording that we have with this proposed constitutional amendment effectively closes that potentiality of non-citizens voting. But we can get those other states for you.
Right. Well, because that's my question. If you haven't looked at those other states' constitutions' language on this issue, then do we know that it is? And I'm not suggesting one way or the other, but if I was coming with a concern that our language was not good enough and I wanted to change it to language that was good enough, I'd want to make sure that it didn't look anything like these other states. So I'm just trying to help you out. If that's the concern, I would look at it if I were you.
No, I will tell you that we did look at the language of what every other state is using when it comes to citizenship and their state constitutions and state laws. And I do know that at least Maryland and California have the same more permissive language as Georgia does. And
The
so
current
that's what we're
language.
trying to- yes, and so that's what we're trying to tighten up. But as far as like knowing the specifics of each of the states that you identified, we can get back with you with that specific information. But it is something that we have done a review of the language that other states are using.
Okay. Thank you.
Okay.
Chairman, if I might say something, that was, if you don't mind,
To get
begin
that,
to Representative Evans'
get your
very good
mic
question.
right
Oh,
there.
yeah. I just wanted to say my understanding with the Legislative Council was that is correct. There was, every attempt was made to, he did the work, obviously, as we all know how that works. And the goal was to put that prohibitive language in, which is now permissive, which he said was how you solved this problem. So I can't speak to specifics of each state, but clearly that was the commonality, as the lady just spoke to, and that was my understanding, was that why the language was crafted by them to be just right in working with the lady here as well, with the Secretary's Department.
All right.
Thank you.
Chairman Smith.
I would, Mr. Chairman.
All right. We got any more questions? I don't see any. Thank you.
Thank you, Chairman. Thank you.
Okay, yeah. I don't know if these two are together, Paul Jacob and Michael Lancaster. Y'all together? Come on up.
Mr. Chairman, members of the committee, thank you very much for the opportunity to speak to you today on behalf of and in favor of House Joint Resolution 780. My name is Paul Jacob. I'm president of Americans for Citizen Voting. We're dedicated to protecting the right of U.S. citizens to have their votes count. And I'm glad to be here with our Georgia leader, Michael Lancaster. Foreign citizens, as has been mentioned, are voting in elections right now in the United States of America, and they're doing so legally. We're not talking about somebody who secretly or, against the law is voting. We're talking about whether we should allow non-citizens to vote or whether only U.S. citizens should vote. Where non-citizens have been given the vote in New York City, Washington, D.C., San Francisco, Oakland, 11 cities in Maryland, 3 in Vermont, they are doing so. And we talk about non-citizens, but in essence, these individuals are citizens. They're just not United States citizens. They're foreign citizens. And again, there's nothing wrong with being a foreign citizen. If we were born someplace else, we'd be a foreign citizen. But they're not just blank slates who are wandering around our streets. They have an allegiance and a citizenship to another country. And the question is whether they want to switch that and be an American citizen. If they do, then we're thrilled with them becoming an American citizen and voting. That's what we want to happen. This is a country built and made great by immigrants. We want that to continue to happen. We want immigrants to come. We want them to become citizens. We want them to vote in precisely that order. The whole idea of non-citizen voting or foreign citizen voting is anathema to most Americans. We talked about the polling has been talked about. We've polled all over the country. We've done national polls. We've done state polls. 80% of Americans, almost every single poll, whether it's 78, 79, 82, they feel like only citizens should be voting. In Georgia, that number was 80, right at 80. And the interesting thing about the polling numbers is that they're not one group. Republicans think this, Democrats think this. Republicans and Democrats are off the charts. Every race, every creed, and so this is in effect a consensus. And it seems to me that these other cities around the country are going against that consensus. And I'll mention one case, New York City. In New York City, the city council overwhelmingly passed non-citizen voting. But we did a poll 3 days before they voted, and 62% of New Yorkers opposed that move. So this is not isn't something that's coming up from the grassroots. The grassroots is very much opposed to non-citizen voting.
Could I ask you a question?
Yes.
Is anybody challenging these non-citizens from voting?
Boy, it's a great question. Yes, and they're being challenged all over the country. California's was challenged, but was upheld. It was upheld for San Francisco to allow non-citizens to vote. And in fact, in San Francisco, you can vote if you're here illegally. Now, if we think about honest, transparent, lawful elections, it seems to me you can't start with allowing people who are here illegally to vote. Washington, D.C.'s is being challenged. Now, Washington, D.C.'s measure allows, this is according to the Washington Post, not according just to me, would allow the Chinese ambassador to the U.S. to vote. It would allow the KGB agents working out of the Russian embassy to vote. It's a crazy piece of legislation. But the truth is, this is a political question. And the courts, I think, and I'm not an attorney, but this is from numerous attorneys weighing in on it, the courts are going to allow this to play out politically. And for instance, the language. Most states have the same sort of language, not precise, but almost to the word, that Georgia does, where every U.S. citizen is an eligible voter. But that has been determined in these other states, like New York and Maryland, who have that same language, that's a floor. It's not a ceiling. So this is you know, this is kind of a rarity in politics to be solving a problem in Georgia before it's a problem. But I like it. And it seems to me that it doesn't make sense to wait until you have Clarkston or another city allowing non-citizens to vote and then try to take action where it looks like you're trying to deny someone their right to vote. This is also happening all over the country on our end. In the last 3 cycles, 6 states have passed these citizen-only voting amendments. Your neighbors in Florida and Alabama have both done this. They did it in 2020. Alabama did it with 77% of the vote on Election Day. Florida did it with 79% of the vote on Election Day. And of course, Florida is a very, very diverse state, which again shows this isn't about, you know, a state being a monolith of one race or one party or anything else. This is supported all across the spectrum. And we now already for 2024, 2 states have put this on the ballot, Iowa and Wisconsin. Kentucky, 2 weeks ago, their House passed it. It now is in the Senate. Last week, West Virginia passed it through their Senate. It's now in the House. And 11 different states have bills, amendments that are making their way through the legislature, including, of course, Georgia. This is something that Americans of all stripes want to see happen. It's straightforward. It's understandable if someone has a different view and wants non-citizens to vote, thinks that that's legitimate in some cases. But it ought to be decided, and it ought to be decided by the people, and it ought to be in the fundamental document. This is the stuff of constitutions. This isn't for a statute that can be changed willy-nilly. And that's the reality. If this body puts this to the voters and allows the voters to decide, this will be forever the voters' decision. If not, then a legislature in any future date could change it. And so we urge this committee and this legislature to give the people of Georgia a vote on this, on House Joint Resolution 780, and let them decide.
Well, the only thing I would add, a lot has been said this today. And again, my name is Michael Lancaster. And while I do lead the Frederick Douglass Foundation, I'm here in the capacity today of Americans for Citizen Voting. The only thing I would add to Paul's testimony is that, first of all, I myself personally have lived outside of this country. For 15 years, I lived in South Africa. I started a school there. I hired staff and teachers. I invested in the students' education. I bought school supplies. Not any time during that time that I was in South Africa was it suggested that I should vote in the elections there. In fact, my visa's requirement was that I maintain the means to repatriate myself here back to the U.S. should the need ever arise. And so with that being stated, you know, as a person who's lived in another country, being a foreign citizen in another country, it's important to realize that we should also have that same standard here in our country, that foreign citizens should not be allowed to vote. I would also add that, as the Secretary said before, it does put foreign citizens in jeopardy of losing their citizenship status. If there's confusion in our state about who can vote and who can't vote, whether it's local or not, it opens up a Pandora's box, so to speak, for foreign citizens to be denied citizenship or even deportation should they illegally vote, because the federal standard is still maintained that you're not allowed to vote as a foreign citizen. And so to clear all the confusion, having a clear constitutional amendment that says only citizens can vote is very necessary. I would also say that, as we said with the polling, a lot of African Americans and Hispanics agree with this constitutional amendment. They feel that having foreign citizens vote in elections dilutes their votes. It makes their votes less effective. And what we've seen in a lot of communities is that there is this concern that foreign citizens are making decisions for these citizens who are already feeling disenfranchised in some ways. And then just finally, just back to the question about the language. 11 states have amended their constitutions to say only citizens can vote. If I was to look around this room and say every male is allowed to come to my house for ice cream, that might be fun. Does it mean women can't come? Not necessarily. Maybe I want certain women to come, maybe not. But if I say only the men in this room can come to my house for ice cream, then I look like a misogynist, right? Because I'm clearly saying no women are allowed. And so that very clear language, changing every to only in our state constitution makes it very clear who is allowed to vote in our elections. And so just with that, we're here for any questions.
Thank you. The question I have is, the language that's currently in our Constitution, is it very similar to what's in New York and California that allows these people to come in and vote?
Yes. Yes. It's almost every state uses the term every. And I think they probably did intend it to mean only, but they used the word every, and the courts have ruled again and again that's a floor, not a ceiling. And only is just so specific that once you put that in place of every, it's absolutely clear. Only U.S. citizens can vote, and so.
Okay, so this will fix the problem.
This will definitely fix the problem.
All right. Any questions by the committee? Representative Crawford.
Thank you. Thank you, Mr. Chairman, and thank you for your testimony. I wanted to know if there is a distinction that you know of, like an error rate between only and every in some of the other states like New York.
I'm not sure I understand what you mean by error rate.
Citizen or non-citizens that are allowed to vote versus if we're looking at the language between every and only. And let's say a New York where you're saying that there have been some issues of non-citizens being allowed to vote.
Well, the reason they're allowed to vote in New York is because the New York City Council passed an ordinance that said non-citizens can vote. And the reason that doesn't get stopped is because New York has language in their constitution that says every U.S. citizen can vote, but doesn't make it clear about non-citizens. If their language said, which is what House Joint Resolution 780 does, only U.S. citizens could vote in New York, well, then it would be clear. And they could say, wait a second, we can't pass this because state constitution forbids non-citizens from voting.
Okay, no, thank you.
All right, I see no other questions. Thank you.
Thank you. I have a copy of the poll, but it's a photocopied copy, and so I will send an original if it's all right to submit it. But if you want, I'll give you
just a second. We got one that came up here. Whip Burchett.
Thank you, Mr. Chairman. I just wanted to, I had done some quick research here and to the gentlelady's point from earlier, both Vermont and Maryland's constitution use the term every. So this legislation does strike that language and makes it only to the gentleman's point. And thank you for that testimony.
Thank you.
Okay. And I don't know if you're accepting documentation, but we do have the Clarkston issue that came up.
Do you have enough for everybody, or do we need to pass that around?
Well, it's just one. It was just submitting it for the record, or we can email it to the committee if you want. Or
now we've learned that you need to get a copy for every person,
yeah.
not only the committee.
Right, exactly.
But there's an article about the Clarkston issue. There are two testimonials from naturalized citizens here in Georgia. And I wanted to read, and then there's also a letter from the Hispanic Action Network, Mark Gonzalez. And I just wanted to read the last paragraph of his letter. He says, "I have led the fight to make immigration reform a reality in our country, but allowing non-citizens to vote is not immigration reform. Non-citizens voting is an anathema to our republic. The German ambassador should not be able to vote in the District of Columbia, while we withhold the right of a non-violent Hispanic American ex-felon to vote. That is fundamentally unfair, and I will oppose that at every turn." So this is just an issue of, we already don't let felons vote, but we let foreign citizens vote. It's not fair. So these are just documents that we want to submit for the record.
Okay.
Along with the survey.
We'll take them, and anybody that wants a copy of it, we'll make a copy for you.
Thank you very much.
Thank you
Thank
for
you.
your time.
All right. Any discussion by the committee? Do I hear a motion?
Second.
Have a motion and a second. Any further discussion? All those in favor say aye. Any opposed? Your resolution goes to the Rules Committee.
Thank you, Mr. Chairman.
All right.
Thank you to all of you.
Thank you. All right. I'm going with Chairman Smith. His bill should be shorter. All right, so. Or where?
I will. Brevity is the soul of wit. I'm sure Rob can tell us who said that. I can't remember. if it
Chairman
was-
Smith, hang on just a second. We got.
Smith, you want this one?
Actually, yes. So the LC that I'm going to work off of today is LC 49-1200. So I know
Yeah.
Brock.
Hang on just a second while we get
All right.
get past that.
Ready to go.
There's a lot of going on in Fulton County today.
Oh, what's the trial? What's the big?
Hamilton.
How's she doing?
So
Good. Good.
Thank you. Has everybody got it?
All right,
Mr.
Chairman Smith, go ahead.
All right, thank you, Mr. Chairman. I bring to you today House Bill 267, LC 49-1200. In short, I believe this committee has heard this bill before. This is dealing with misclassification of workers, basically those trying to circumvent our laws by misclassifying the worker when they should be an employee or an independent contractor, and they make them an independent contractor instead of a regular employee. So that's in essence what the bill would do. I am going to submit to the committee one change, and it's going to be on line 14 where it says any person. I apologize to the chairman. I had a substitute that apparently we didn't get to you. But anyways, what I would propose to the committee to do is to change where it says any person, change the word any to any aggrieved, or maybe that should be an aggrieved person.
Oh, an aggrieved.
I believe that may be the proper English. I know I have some very talented lawyers here that know how to use the King's English the correct way. And so just to make sure it reads correctly, an aggrieved person. And if we had passed this last year, it would have been the Queen's English, just for the record.
All right, any questions for the author? Representative Kelly.
I just remember, Mr. Chairman, we've seen this bill a couple times, and you want to, short and sweet, motion to pass, and we can get to amendments if we.
Is there a second? All right, we have a motion and a second, and we've heard the proposed amendment from the author. Any objection to that? I guess I should say, do I have a motion on the amendment?
So moved. Second.
All right, all those in favor say aye.
Aye.
Any opposed? All right, the amendment's on. As to the main bill, any further discussion? All those in favor say aye.
Aye.
Any opposed? All right, bill passes. Goes to rules. All right. Representative Momtahan, you have been very patient. I do appreciate it. Sorry to hold you to the end.
Motion to table.
Move to adjourn now.
All right.
We've passed our 4:15 timeline, Mr. Chairman.
I would be so mean. 'Cause you were here the whole meeting.
You know, I try to be respectful of this, very respected committee. I look at all these respected committee members and represent Mitchell Scoggins. So I know how serious y'all's time is, and so we'll try to get through with it. I did opt not to shave halfway through the committee meeting, so if I'm showing a shadow here, I'm sorry, Mr. Chairman. Today I bring to you House Bill 934. It's LC 442653S. Everybody's got that. House Bill 934, I'll give you the purpose of the legislation. This bill allows for not just the delivery of contracts by email, as already specified in law, but the execution of contracts by all electronic means for the use of self-storage facilities. Many operators of self-storage facilities execute registrations for rentals online, as well as having in-store kiosks and tablets. By specifying electronic modes of contract that are acceptable, this assures that these modern practices are enforceable by state law. You'll see that in line 161 of the bill, where it says a rental agreement may be executed and delivered electronically. The reason for the bill is that sometimes operators need to terminate a contract with a person who has rented a unit for other types of reasons. And so typically this will be because the renter is either doing something illegal or inappropriate inside of a rented storage unit. However, Georgia law only has a process for removal of items from self-storage units due to non-payment, which is the lien process. In this case, operators find themselves with problems when needing to remove someone who is paying their bill but otherwise is causing an issue. This legislation is intended to provide a remedy other than the lien process or an eviction process. You'll see those changes starting on line 164 of the legislation under Section 2. And I can read that to you, Mr. Chairman, or let y'all absorb that for just a moment. With that, I do have some real-world examples here that we can go through as the committee has questions, but I also have some folks who would like to testify with me today. If that's appropriate for you, I can take questions first.
All right, any questions for the author? Okay. All right, if you have someone you want to bring up.
Yeah, that's fine. Yeah, go ahead and come on in. Yeah, perfect. Here, let me move out of your way. Sit right here.
Good afternoon, Mr. Chairman and members of the committee. My name is Joe Doherty. I'm with the National Self-Storage Association in Alexandria, Virginia. I'm also a graduate of Emory University. I was on the crew team, but I promised not to talk about water. Or now, yeah, we rode at Stone Mountain. I think that's going to be okay. So this bill, as the representative mentioned, does three things. The first one I think is fairly straightforward, with electronic contracting becoming much more prevalent, especially after the pandemic and concerns about being close to people and the movement toward online contracting. The second piece of the bill allows for, I think of it, we all have Netflix subscriptions, or we have various subscriptions where we'll get emails from time to time or notices through the mail saying the terms of use have changed. If you continue to use the service after this date, you'll be bound by those terms. That's what the second piece of this legislation does in lines from 165 to 169. And then the balance of the bill from lines 170 to 181 deals with the issue that the representative mentioned, where the existing process in Georgia law speaks only to when somebody stops paying for their storage unit. We have a wide variety of examples of people who they are good at paying, but they're not necessarily good at everything else in their life. Examples such as people who have drug labs within storage units, people who are living in a storage unit. A couple of examples of people storing items such as cooking oil or onions, where they rot in the storage unit and cause thousands of dollars worth of damage. There's not an existing process to resolve those situations quickly. And that, without going, and Mr. Zucker here, he's a Georgia attorney, he can speak to the exact process that would be followed now. But there's not a quick process to address those issues, and that's the primary piece of this legislation, again, from lines 170 to 181.
Okay. Y'all want questions now, or?
Well, maybe if Mr. Zucker can speak to the existing process, and that might answer some questions preemptively.
Good afternoon, Chairman, committee members. My name is Scott Zucker. I've been honored to be the counsel for the Georgia Self-Storage Owners Association for 35 years. Been before this committee, and you've been very responsive to our issues as an industry over the years a number of times. This has come out of frustration with the courts that self-storage rental agreements are month-to-month commercial leases subject to termination both by the tenant and by the landlord. And we've had situations, as Mr. Doherty's identified, where tenants would otherwise be paying, so there's no monetary default, but they're behaving badly, living in units, committing crimes in units, harassing managers at the facilities, numerous events that tinge to criminal that are not resolved by the police removing the tenant. Their property is still in the space, but we then are forced to deal with the eviction process after giving notice of termination. And the courts have been very frustrated with the fact that we have a remedy with the foreclosure law. So many times, and I've done this for a number of times for many facility operators, have filed eviction actions in the courts, been refused by the court to handle it because there already is a foreclosure process, and a lot of misunderstanding about the resolution of the removal of the property. Again, this is non-residential, the removal of property from the space. So this provision in the statute is a solution to the removal of the property after a tenant has been terminated but refuses to vacate. It's as simple as that. I mean, it's the removal of personal property or business property from the space after a tenant has already been terminated, which remains the right of the landlord. This is an effective remedy, we believe, and resolves the frustration of the operator and the industry to this issue, and is being done, as Mr. Doherty's identified, around the country to modernize self-storage statutes. So we're just here in Georgia to do the same thing.
So from breach to, where you kick them out, what kind of time period are we talking about?
So the language of the statute is to model the self-storage statute now for foreclosure. There'd be a notice of termination, a 14-day opportunity to remove the property after notice, and then after that would be the disposal of the property.
And the scenario I think of is somebody who's had a stroke or has died, and no more money's coming to pay for the unit. What happens there?
Yeah, then again, it's a 14-day notice of default, a monetary default. If someone has died, a failure to pay. Then after that notice, publication of the ads, consistent already in the statute, and then the sale of the property. It could happen as quickly as 60 days under the foreclosure process. This is dealing with someone who is otherwise able to pay, but is otherwise behaving badly at the facility in many respects.
Okay. All right. Representative Kelly.
Thank you, Mr. Chairman. Agree with what we're trying to do here. Makes sense to have a document, be executed and delivered electronically. I guess my question starts in section 2, subsection A and B, and we have where you can renew agreements through inaction. And I don't necessarily have a problem with that, except I wonder about if I'm in a contract where I'm renting a unit for $75 a month. It's set to expire. You email me a new lease agreement where it's gone to $150 a month. It goes to my spam folder through really no fault of my own, because I imagine some of these are auto-populated and things, and it goes to my spam folder, and I never get notice that my lease is now doubled in cost. Is there anything we could do to, because if it's hand-delivered or it's delivered through certified mail, then we know the person's receiving it to get that. My question is, how do we do it with email to where some people aren't caught in a gotcha situation with their lease? And the same goes, my same concern goes to subsection B, where you're saying, I want to terminate, you send me an email, it goes to my spam really through no fault of my own, and then I'm stuck in a situation now where there's a kind of a fast track for my property to be removed.
Actually, it's a simple answer. You've already addressed that in earlier iterations of the statute. We do everything by email notice for the foreclosure lien. As an example, you're not paying, so we send you an email. But if the email is non-deliverable, as notified as non-received, there is a solution in the statute already that the notice is then sent by what's defined as verified mail, which is first-class mail with certificate of mailing through the Postal Service. So that's already addressed in the statute and reaffirmed here by the phraseology hand delivery, verified mail, or email. So if the email is rejected earlier in the statute, there's an obligation by the facility operator to send the notice by U.S. mail verified, which is, again, first class and certificate of mailing.
And I understand where it's undeliverable, right? Like if I send an email and I put, instead of at yahoo.com, I put yahoo.con, that kicks back to me, it says undeliverable, and then it's on me, and I look and say, oh, I misspelled com. But what if it's a valid email, but the email filters it to spam, so it's delivered, but it doesn't go to the inbox? I don't know how anybody would have notice of that, either the sender or the receiver.
We've addressed this in other issues. You want to take it?
I can answer that question, Representative. In order for someone to receive these notices by email, they have to opt in to receive that notice by email, so they would have the opportunity to put that email address onto their clean list, so to speak. So I understand the scenario you're presenting, but I don't think in practice it would come up if you've put that onto your clean list, if you've opted in to receive by email. If you don't want to receive notices by email, then you don't opt in for that option, and you would either get them by U.S. mail.
And do y'all always use the same email to communicate? Because like I have trouble sometimes up here. I have a personal Yahoo account that I send most of my communications here within the Capitol to, and there's some individuals who I've had to, a lot of the house.ga.gov emails, especially committee meetings and things, go to my Yahoo spam account. And so I'm trying to, so then when I realize it's in a spam account, I'll go and I'll add Antarctica to my clean list. But if Brock sends it out instead of Antarctica because she's not here one day, it may go to that spam. And so do y'all always use the same consistent email to communicate?
The statute talks about sending notice to the last known address as defined by what is provided by the occupant.
No, I mean, do y'all always use the same email to send out?
Yeah, once we're provided the email by the tenant as their last known address or email address for communication, that's what the facility would be oblagated to use to send notices.
No, the email that the facility uses, is it always like Mark at selfstorage.com sends your renewal, or could it be Dave at selfstorage.com? That's my question.
I don't know if I can speak to the consistency of what each operator would do with regard to these notices. If it comes from the same address, consistently it likely would, because their software management is set up to be sent from a source. So it typically would come from the same email address, but I couldn't validate that would happen all the time, but you would think that would be the case. And let me add that if in fact, under your scenario, there's some confusion over the rental rate or some execution of the document that leads to ultimately a default for non-payment or something like that, then again, the statute calls for a whole series of additional notice and advertisement before anything would happen with the property for sale. So your scenario deals with a good faith tenant, maybe some dispute over the email communication, something different that would ultimately potentially lead to their monetary default situation. This addresses, a bad behavior tenant who has been sent notice of termination, refuses to leave, giving the operator a remedy of taking back the space for a tenant who's otherwise breached the lease. So your scenario is a little bit different with respect to, respectfully, what would be a monetary conflict.
And that's in A, when we're looking
Oh, no,
at 10.4.218 subsection A is only dealing with people who are bad conduct, because I have concerns about people being bound to a contract that then could be found in default of a contract that they didn't know they had entered into, and then have a monetary judgment against them for a contract that they entered into without knowing they had entered into it. That's the scenario I'm trying to walk through in my head.
The intent of this, again, on this part specifically, was the scenario that we're trying to deal with a frustration of scenario with tenants because of the unmanned facilities and the way that kiosks and mobile applications are being used. Tenants are moving into facilities without signing rental agreements. So they're taking space, they're using the services of the facility, but they're failing or refusing to sign rental agreements. So the solution is that you could send the tenant the rental agreement, even after their occupancy of the space, asking them to execute the document, and they would refuse. If they're occupying the space and they've received this communication about the rental agreement, they should be obliged to the terms and conditions of the agreement, as well as renewals. But this is to address,
And so
again,
it's-
bad behavior.
Okay.
That's the intent of this additional language, because the execution of the document is addressed in other parts of the self-storage statute as to how a contract's created. There could be verbal contracts in self-storage under the statute the way it's written now.
You good?
Maybe as good as I can be, Mr. Chairman. I kind of wonder about the scenario where someone has an existing agreement, and it's. I'll let others have.
All right. Representative Oliver.
Direct your attention, please, to paragraph A, 165. Is there any other circumstance under which a person to a contract is deemed to have executed the contract simply by a period of time when he or she has taken no action to execute a contract other than delay of time? Does that exist anywhere in the law for any other contract provision?
I can't, maybe
Yeah,
Representative.
I speak to
Yeah.
I don't know if they can hear me, but thank you, Representative Oliver. I know that as a small business owner, we have credit card machines that we utilize in our business. You'll see them everywhere, from what they call point-of-sale machines. And these credit card readers, point-of-sale machines, utilize software. In those agreements, they are also automatic renewed.
I think my question's a little bit different.
Yeah, I'm thinking in the real estate context where a tenant has taken occupancy of a space but not signed the agreement. So they've by acceptance of taking the space, by an agreement presented to them, but they have not executed, but they've taken possession of the space. I'm thinking about in the real estate landlord-tenant context.
Is that statutory anywhere?
No, I mean, I can't speak to that.
So
I'm
this
not
is
familiar
unique,
with that.
that we are deemed to be a party to a contract simply by the passage of time.
I don't know how you get a meeting of the minds there.
Right, there's not an agreement. Well, he's by statute saying there is an agreement if you just do nothing for 14 days.
Let me clarify and ask this question because I understand your point, and it's well taken, is the issue, and I'll use the Netflix example, of someone who's taken use of the service and then there's a change to the terms, right? And notice would be sent out to the participant in that agreement for the change in terms. Is there an obligation? I mean, that would be deemed to have acceptance if they continue to use the service, and that's the intent of this. Is that?
But with Netflix, there was an original agreement that I was going to pay $10, and you're only referring to the renewal of the $10 up to $12, and this reflects, I think, the initial contract between the storage owner guy and the tenant.
Yeah, and the reason of that language, and you're right, is to address the, again, bad faith of the tenant taking occupancy but not executing the agreement, subsequently sending them an agreement, hey, you didn't sign this agreement, we need you to sign this, and their refusal to do so.
I
And
don't-
yeah, good.
I guess what's troubling me is that if I'm a landlord, do I give the keys to a tenant who has not signed the rental contract?
Not intentionally, no, but in self-storage, they can take occupancy, they use their own locks for their own spaces, right?
So I go up to a self-storage entity near my house with my own lock and let myself in and put a lock on the storage unit, and nobody's given me a piece of paper, and I am a tenant? If I can't figure out when the contract, if I just basically trespass a storage unit and open up
Absolutely.
the door and put my lock on it,
Yep.
that's legal, and
Yep.
I can stay there without a written contract?
No, you are a trespasser, and that's exactly our frustration here, is because of the technology issues that people are able to take occupancy. We cannot remove them. It goes back to the eviction statutes. There's really no way to do it. I mean, the police will not remove a tenant in their property because we say that they haven't signed an agreement. They say it's a civil matter. So we're just trying to solve the problem of a tenant taking occupancy in the service of the facility, taking the space, having not signed a contract, and therefore sending them a contract, hey, you didn't sign this, and asking them to execute it. I'd be just as happy with your point to somehow incorporate their failure to execute triggering Section B, which gives us the right of termination notice because you didn't sign a contract, and allowing us to dispose of their property. It's ultimately the same thing. I don't need to enforce a contract that they haven't signed. I want
You just want B.
I want B, yeah. But A is part of B. I mean, because actually, if you're willing to do B without A, my problem is that sometimes, people will say, well, there's no signed contract. And then we're left with this ambiguity of a occupied space but no signed
The
contract.
benefit of B is that you've given them notice of some kind. After owner has delivered notice of hand delivery, verified, or email, then you can take their stuff in 14 days. At least you've given them notice. Under A, they have no notice that they are now a party to a contract that they haven't signed. Where am I wrong?
Representative Oliver, the beginning of A is, it does require delivery of that written agreement, either by hand delivery, verified mail, or email, so they do have notice of that agreement.
That they're pursuing, that they're reviewing, that they're thinking about, but it doesn't say if you don't, well, I guess your contract, if we go with this, would the contract you give to somebody say, if you don't sign this in 14 days, we think you've signed it? I mean, is there any kind of notice on it
That would certainly be the practice, if it's the will of the committee to make that clear in this language, we would certainly find that acceptable. But it's not simply a matter of inaction by the person. Yeah, they've stored their goods. The owner has provided them with the document, and at that point, it's when the inaction then kicks in, that they're not signing that agreement, but they're continuing to use the service, and only after that 14-day period has passed are they then bound by that agreement.
Then, Mr. Chairman, a notice provision that says, I've given you this contract on February 15th, and if you don't sign it by February, trying to do it 29th
this year,
we're going to deem that you've signed it. That makes sense to me, but no notice about, here, look at this. Go ahead, move it, look it in, and then but you've answered my question, thank you. There's no other circumstance that we can think of where somebody is deemed to agree to a contract that they haven't signed based on purely a period of time.
All right. Representative Silcox.
Thank you, Mr. Chairman. Just a question on dispose, first of all. Dispose is kind of a broad term, and does that mean that y'all just throw it away? Does that mean y'all sell it, make a little extra on the side? What does that mean?
It is a broad term, Representative Silcox, and it could mean either sale or put into a dumpster. if there are any proceeds from a sale that are more than what the tenant owed, and in this case, we're talking about a non-monetary default, so if it's sold, there would be excess proceeds. Those are either returned to the tenant, or if the tenant doesn't claim them, they are turned over to the state as unclaimed property. So the owner is never going to be able to line their pocket with this money if it's more than what they're owed. And that's true of the existing lien process.
The reason I
as
ask
well.
is because I have a friend that was in a really bad situation, and her grandmother died. Everything was in a storage unit, and they were living in another state, didn't get notice, didn't know about these emails or whatever. They didn't know anything, and all of her grandmother's things were just gone.
That's right. Mr. Chairman, if I may, in Forest Park, they had an issue where a customer had just crates and crates of onions, and they rotted. And you can imagine the flies and everything else that were crawling all over these onions. That's where you'd want to dispose of these.
Of
And then you
course.
have remediation. There's another one where a customer used these great big crates of used cooking oil and drums and everything, which created a remediation issue that they had to go back in, so they had to dispose of them. So that would be a disposal issue on that end, whereas there's also a remediation of money to the tenant. I just want to.
I guess I'm just concerned about heirs to property, and would there be, I don't know that y'all keep that information if somebody's, gone into the hospital or is about to die, that's one of your tenants, do you ever collect any other additional information like, hey, who's going to be the executive of your estate or anything like that?
So the way the statute deals with that, Representative, again, that's the existing statute with the lien process for non-payment. And the way the statute deals with the concern that you've raised is to require the owner to have space in the agreement to designate what we would call an alternative contact. The statute calls it an agent.
Okay.
But to designate an alternative contact. So if I'm not doing well, I might designate Scott Zucker as my alternative contact.
Okay.
Or I might, my wife or a child or something along those lines.
Well, that's good to know. Y'all are
So
contemplating
there is that
Okay,
process.
thank
It's
you.
not simply the notice going out to someone who might be hospitalized. It would also go out to this alternative contact.
Thank you.
All right, Representative Kelly.
I don't, kind of going to Representative Oliver's point, I don't think I have a problem with a contract by inaction as long as I can guarantee there's been some form of notice that's given. And the scenario I keep hearing y'all talk about is someone who just comes in and I think squatting, that you're trespassing. So I'm, those individuals, y'all likely would not have an email for to begin with.
Correct.
So if I were to strike, possibly as a potential amendment, strike or email on line 166 and maybe do a little cleaning up there to make it fit right there, that wouldn't be a problem for that scenario, right?
My only answer to that is I wouldn't want to strike the right to send by email, because a lot of people will only provide, their email for a typical. This deals with multiple bad actors of tenants. We want to make sure we include those that have given us a signed rental agreement, but are behaving badly and gave us their email address. We want to be able to give them notice by email of the termination. So there's two different issues here. One is, again, the notice issue that you're addressing with regard to just the lease, and I'm trying to address the issue of the bad actor that either doesn't sign the lease or behaves badly but won't leave. I mean, so it could be and or email, I guess, to answer your question in terms of logistically. I mean, I'd like to leave email in there because a lot of times it's only the email that they provide.
But I think what we said the problem we're trying to address is for someone who just moves in overnight and next day you show up to your self-storage and they're there. I don't know how they would have previously provided an email.
Mr. Chairman, Representative Kelly, if if I understand what you're suggesting, it would be removing email as an option from section A,
Yes.
but keeping it as part of section B, which I think addresses what Mr. Zucker is
Yes.
referring to.
I'm trying to get to the quote unquote some form of meeting of the minds, which is as we know, basic contract provision. I don't know how. I really don't know how you can have a meeting of the minds if you send me an email and somehow it doesn't get to me. Whether no fault of yours, no fault of mine. It's just the email filter. That's just where I have a problem with someone entering to a rental agreement. You'll still be able to send them a rental agreement and them by email, and they can renew it, but it'll just take some proactivity on their part. This is a new form of auto renewal that requires inaction. That's where I mean, if you want to still send someone a renewal by email, you can, but they'll just have to electronically sign it like we're giving you the provision to do on 161. But if you want to automatically get someone to renew it without them signing their name or initialing, I think we got to have more than just an email sent for that. I think we need some form of either hand delivery or certified mail to make sure that we have a full meeting of the minds, if that makes sense.
Yeah. Yes, Representative Kelly, that makes sense.
Thank you.
Whip Burchett.
Thank you, Chairman. My question is along the lines of Representative Kelly's. So, do y'all have a gate on the front of these to get into your storage facility, or is there a door?
Representative, yes, typically there is a gate or a door. The problem, if I can anticipate your question, might be that somebody just tails the car prior to them into the gate or something along those lines.
Okay.
I think the scenario Mr. Zucker is referring to is that the person does they're not a true trespasser, if I can use the hated word of squatter. They're not in that. They've come in at least somewhat legitimately. Yeah, they've gone through some of the process, but they haven't, as part of that process, completed it by executing the rental agreement. So they're typically a known person, but they just haven't finished out that process, but they are occupying the space. And it's how do you deal with getting them fully to finish that process and have that lease be binding on them?
So run me through your process. I come to your facility. I want to get a storage facility. What do I do?
If I may, Representative, there are a few operators here who I think can better address that scenario than I can.
All right.
Let them sit here. Right here.
Yes, the old lady in the room. Good afternoon.
Afternoon.
Yes. And thank the committee for letting us speak. My name is Ann Ballard, and I'm the president of Marketing, Training, and Developmental Services for Universal Storage Group, located here in Atlanta for over 30 years, 34 years, I think. I've been operating self-storage facilities. And primarily, and especially with the pandemic onset, when we couldn't be with you face-to-face, we initiated an online rental process. And in every instance of the issues we're talking about today, this is perhaps Ms. Oliver rented online, paid the money. It's always the case that the money's been paid. They've agreed and seen the entire document, initialed a lot of places, but there's some software glitch about getting them to actually sign it online. So we save that, they come in, sign it, we get a picture of them just to make sure they're who they say they are, to protect the owner's asset and of course protect the customer. And in many cases, in a recent audit I did of the number of unsigned leases at our many properties, we have mailed the lease, emailed the lease, attempted to text it with a link, and they're still paying and they're still in occupancy, but we have no unsigned lease. So Scott Zucker, our wonderful attorney, gets all these calls. Scott, what do we do about this? He says, keep sending them. We keep sending them. they always provide the email address and verify that that is, to answer the other young man's question, that that is in fact how you spell it, how the .com or Yahoo or whatever it is, and they always provide their written other address for the verified mail. And if those addresses go bad in the operating system, we're alerted, and then we tend to even double the efforts to reach them, get the correct info, because storage facility customers like to keep in touch and know how things are going, and as they mentioned earlier, the many ways that we try to take care of those who've had very unfortunate circumstances kind of above and beyond, and especially it comes to mind with cases Scott and I have dealt with military persons who have passed away, and we've really tried to go above and beyond to, you know, do everything we can for the consumer. But the issues we're dealing with here on these two paragraphs, and we thank the committee for all the times through these decades that you've helped us get better and better circumstances to help Georgia operators. But this is for when the person has paid and they continue using the space, but for some reason I cannot get you to answer my mail, my text, my email, and just sign it. And at a recent facility, 84 of those were turned up out of 700 and something units. So we have an issue. The other part B is, I'm very passionate about storage, so I apologize, y'all, but is when someone's been living in the storage unit, which is clearly not allowed. Our managers are doing lock checks, making sure, you know, everything's how it should be. And we've terminated the lease, and they won't leave. Well, it's not a default for non-payment, for which we have our process, you know, for the lien sale. So we have no way to do anything. And as Mr. Zucker and Mr. Daugherty both mentioned, the police have their hands full with other, I'm sure, many more pressing things, and they don't consider this something that they're going to deal with. So we, on both cases, desperately need your help for the path. And having the customer give us and ensure us that the email address and the mailing address that they gave and then the money they pay was initiated by them and confirmed by them. So they're in occupancy, but we can't manage them in any way, shape, or form because they won't sign the agreement or they won't leave when terminated. So those are, and I have a lot of stories, as Mr. Daugherty knows, but those are the critical issues facing us today in this world where we literally have to do over 40% of the leases online. So it's something we need help with.
Thank you for that. Is the so is there any way to just get them to sign it before you issue? I mean,
not online. You want to go ahead and fill out most of the stuff and put in your information and give us the money, and then we give you an unlock code so you can come in and see us and get in and put your lock on it, you know, and we can facilitate what you need, which is to get your storage unit rented and go on about your life.
do any of your members utilize the kiosk where you go up and you type in your information and then you sign right there and get your lock, one of your locks?
Yes, sir.
Is that working?
Consumers prefer their phone over an on-site kiosk. So at the facilities where I've had kiosks for years, the usage is not very high. They really do prefer to just, like I do when I book my own travel, just use my phone. So,
Have you ever considered utilizing just a notice provision to just put it on the outside of the storage?
we have managers who've done that as well.
Is there a problem with doing that? Seems like that would be a lot easier.
When you say notice outside, what?
On the unit.
Oh, the lease itself on
Yeah.
on the space. I mean that makes sense, except that a lot of tenants will move in and then go wherever they're going to go for months at a time, and may not see the lease. We're trying to get them the lease, so we are trying to deliver it, if through this provision.
I'm thinking about your specific issue where somebody just walks up and goes in and utilizes it. You don't have any information on these people. You don't have any
email, contact information.
Yeah, that's called a ghost or mystery tenant.
Yeah, so you just see a lock on the door.
So mine was probably the more dramatic one than what Ms. Ballard's identified. But I mean, and you're right. There's kiosks, there's mobile apps. What we're dealing with is the reality that even with that technology, there are tenants that may not complete the application process and still move in. There are kiosks there. They're just tenants, some good, some troubling, some mystery, that are inside the facilities, and they haven't signed a rental agreement, and I'm trying to enforce terms of an unsigned rental agreement, and it's problematic. I mean, it's certainly problematic if there's any dispute that arises between the tenants. They've entered the space without a signed contract. We're just looking for a way to create a fairness that there's an executed contract for a tenant that's using the space.
Have you ever heard, it's an old lawyer, I don't even know what to term it, but you've heard the saying that you get the silver while the tear is in the eye? You remember? You've heard this? So that's Barry's story, that's right. Well, former chairman of Judiciary used to say that a lot. And so the problem I'm having is, I'm not opposed to the bill, but you have control of what, you say you take the money, you issue the unlock mechanism or code. You have control at that point to say you don't get it unless you sign this. So that's where I'm having the problem, to say, like, we're having to jump through a bunch of hoops here when you are the operator. You have the ability to require that they sign before you get an unlock code, right?
That's certainly a path we could take. But we're business people, and we'd like to be able to make a living and pay our taxes and do all of that. If we said, okay, customers, for example, in one of our tests, we said, okay, customers online, you have to prove who you are before we'll let you finish the process. 82% of the customers dropped out, and we lost those customers just from asking them to show their driver's license to their phone. I mean, it doesn't get any easier than that. And in our test, we lost 82% of them. So certainly I can, be, as Mr. Zucker knows, a stickler for the rules. But I have to run a business too. I have to, put money in the banks of my clients. I manage their facilities and compete against the big guys. And the big guys have this same problem, public storage and extra space. I mean, they're facing the same problem. So it is something. But if anything, the paragraphs could be preceded by saying, if the customer has paid and moved in, we didn't make that up, and they wanted it,
There's an implied contract there.
Yes.
Right, if they're in possession.
Yeah.
Yeah.
Yeah, Mr. Chairman, if I may, the paragraph A and starting in line 167 does require the occupant's continued use. So it's not as if these people are unaware that they're using a service and they're going to be bound by that contract.
Yeah. That they didn't sign. Okay. Thank you.
Thank you very much.
Okay. Representative Evans.
Thank you, Mr. Chairman. This scenario where somebody just moves in, puts their lock on, is this happening at facilities that are unmanned, as in you don't have a physical office there, perhaps?
Where
Or
someone
a
has
gate?
not paid and they just see an open path and put stuff in a unit? Is that the scenario?
Well, I mean to address the scenario that you're trying to address here, where somebody doesn't sign, but they've moved in, and you want to say, well, you moved in, so you got an implied contract. Like, how does that logistically happen?
They go through the
Excuse
online.
me.
I'm so sorry.
I'm sorry. You need to get into that microphone.
I'm
We
so
got
sorry.
people on the line listening to this,
so
and
sorry.
if you're away from
The
it, they're not
chair's
going to hear
got
what
a
you're
sunken
saying.
bottom. I sunk down into it. Sorry. I'm so sorry. Online, they would have given their personal information, given their credit card.
Mm-hmm.
The card would have processed after them telling us their email
Mm-hmm.
address, name, phone number, some basic information we have to have. the card would have processed, saying that it does match that name, that person, that place, and then it would give them a gate code, and in the case where we have some digital locks, a digital lock code. Because once the credit card processes, that's the biggest concern of the operators, making sure we've got everything done. And their rental agreement would have automatically been emailed to them at that minute of their payment to that email address they just gave us, and that was verified by the credit card company as the one belonging to that customer, or the address of that customer.
So why just? I'm trying to figure out why you need a law, because why can't you just put in your form, me giving you my name and putting my credit card information, you check a box that this means that I'm in and that I'm on a month to month, or that I'm on an automatic renewal if I don't cancel or whatever. I think I can think of many things I buy online. I never see anybody and I just agree.
Yeah.
So why can't y'all just do that? Why do we have to do it?
You're helping us address the tenant that has not fulfilled exactly that point, that has not fully executed the acknowledgement of the contract by execution of the document.
But why not? I don't mean to interrupt you, and I'm sorry.
Yeah.
It's just been a long day. But why give them the code before they've clicked all the boxes?
And I think that's answering the other representative's question. Is it's not as if the facilities are intentionally allowing this to happen. Certain tenants will go through the process, not complete it, and somehow still, through technology and the glitches that happen as we're evolving this technology, take occupancy but not fulfill the execution of the contract. That's to answer this gap of someone honestly in good faith not fulfilling the contract, then not signing the contract after the fact. So we're trying to fill that gap by sending them notice. If they're continuing to occupy, they're deemed to have accepted the terms and conditions. A little different from your initial point, and the topic that I raised, which is most frustrating to me, is not every facility has a fence around it. Not every facility has gates. There are tenants that have occupied the spaces. And in some communities, local communities, they're fine with that. They go to the tenant. They actually might know the tenant who's just moved in. Say, you need to sign this rental agreement, and they go, I'm not going to sign it. I'm taking the space, but I'm not going to sign it, because they don't have a fence or a gate. They just have a facility, and someone's moved in. I'm trying to solve the problem on behalf of the landlord to create the fairness of the balance of a contract. Of what do you do with an unsigned contract with an occupied unit, whether by not bad faith, just mistake, failure to complete the contract, or by intentional trespassing.
And that's paid for, because we have a remedy if it's not paid for.
In the second section.
Yes.
The first section is to create the enforceability of the contract.
Yes.
Yeah.
I'm just trying to figure out how, if I give somebody a gate code, I don't have a gate code to my house, but if I did and I just gave it to somebody, or I gave them my keys and then I let them come in without me getting whatever information I would need to follow up with them, or get their credit card, or get their agreement signed, or whatever, I feel like that's on me. And I feel like, why, I guess just to put it back to you, why can't you just fix your system? Why can't you just, like every other business that doesn't give out their product until it gets paid for? I mean, and if you have gaps, that's a business problem, not a legislative problem.
It is. It's a legislative problem for those that are intentionally circumventing the system, and we are having because of the service that these operators are trying to provide with unmanned technology access facilities. This gap is happening of unsigned contracts. In the perfect world, in the old days, I'll phrase it this way, where a manager lived on site and no one entered onto the property unless they signed a contract, because these managers lived on site. That's no longer the case with the majority of facilities in the state, or actually in the country.
But in fairness, the unmanned facilities are saving money by not having staff that they could have. If this is a problem, then maybe you need to staff up, instead of asking us to take the burden of what is a money-saving issue for the industry by not having staff, not having gates, not having all that. That's not with all due respect, I don't think that's our problem. I think it's an industry problem.
Well, we are fully staffed at ours, and we still have this problem. And these managers work diligently to not only meet the letter of the law, as we have trained them many times to do, but to, give the customer good service and keep the customer happy and referring their friends to us and all the ways that a business keeps itself going. But there are cases, in the one audit, I think it was 80 out of 700 and something, where we have just failed from every attempt to get a signed rental agreement. They're paying the money, they're staying, they're loving it, everything's great, but nothing has worked to get this signed rental agreement.
Well, one last question then. If they're paying, what's the problem?
We have an unsigned rental agreement.
But you're getting the money. So what do you care?
Well, we are.
Well, but sometimes the likelihood of a dispute between parties can occur. I mean, we're just trying to deal with compliance, and therefore you have an unsigned contract. And I will tell you that the courts are reluctant to enforce either the rights or obligations of both the landlord or the tenant without an unsigned contract. You have a lot of ambiguities that simply the operator is trying to avoid by getting the tenant who's using the space to sign the agreement. So I understand what you're saying. These folks are trying very hard to get their tenants to sign the agreements, but it keeps coming up. Now, if I was to tell you my majority concern would be Section B over Section A,
Yes.
but since you're looking at it and we're trying to solve an industry problem, I'd say, the reason A is added is because we have many operators that are part of the state association as well as the national association that seem to be dealing with this frustrating issue of occupancy with unsigned contracts. I'm not going to tell you it's a national catastrophe, but it's a problem that could be solved while the legislature is also looking at the issue of this termination issue. That's why that's why it's been added to the statute. Basically address all these concerns at one time.
Thank you.
Representative Kelly.
Mr. Chairman, I was just going to make a motion, do pass, and then hopefully have an opportunity to offer some amendments and discussion.
Okay, hold that thought just a second. Anything else y'all want to testify to? Any other witnesses here? I don't think so. I don't have them on the list anyway. All right. I have a motion. Is that correct?
Yes, sir.
Is there a second?
Second.
All right, I have a motion and a second. Any amendments?
I have one that I'm certain of how I want to make it, and then I have one that I'd like maybe to get some input and feedback on the best way to make it.
All right, let's talk about amendment number one.
Amendment number one would be simply striking the comma after delivery on line 165.
Wait a minute. Oh, that. At the end of the.
Mm-hmm. Inserting the word or. Then on line 166, striking the comma after verified mail. And then striking or email.
Any questions about amendment number one to the author?
I actually did have one question about verified mail.
Pull 17 or 16, whichever one it is.
I had one question, Mr. Chairman, about just the word verified. Is that a term commonly used in code, or is that a term that has a particular meaning in this business?
Representative, that's defined in code.
Okay.
And, yeah.
Okay. Thank you, Mr. Chairman.
Yeah, because most of the time I saw certified instead of verified.
It's referenced a few other times through the previous sections. Like just one place I see it is line 103.
It's in the definition section of the beginning of the statute.
On renewals, I do, or first pending agreements. I just think I don't know how you get a meeting of a mind without knowing both sides have reviewed it. So that would be my motion. That's my amendment for that.
All right. let's see, do I have a motion for acceptance of amendment number 1?
I'll make the motion. I just need me a second, I hope.
Yeah, second. All right, have a motion and second. Any further discussion? All those in favor say aye.
Aye.
Any opposed? All right, amendment number 1 is on. What's amendment number 2?
My second amendment would be aimed at kind of what Representative Oliver was talking about, having a notice provision in the agreement that says, that if you don't, and this is where I want input from Mr. Zucker and from the committee on what that language would look like. Something of, because I guess you'd have to explicitly say, I'm not. Like, how would someone say, no, I'm not going to renew, or no, I'm not going to accept this? How do we do that? We say if it's not rejected in writing, or if it's not rejected, or because I'm thinking about some language on notice that says, maybe help me with that, Mr. Zucker. I don't know.
Is your question that it be contained in the rental agreement?
It's some kind of notice that when you send this to me, that, hey, look, if you don't do anything, like when you hand deliver it to me, you verify mail deliver it to me, and then you say, how do I know that if I don't do anything, I'm automatically bound?
I would repeat the language in lines 165 to 169 in the notice. I mean, I think I'd be fine to say that this language would need to be included in the notice that's being delivered.
So
the enforceability language that you're talking about.
Yeah, and so I know earlier in here we have what I guess is this like a standard agreement for y'all? This language, is this what everybody uses?
Yes.
So should we just put that language in somewhere in that? Or should we put it at the end of section A? That's where I was wanting to get your input.
Representative, I would suggest putting it at the end of section A, because
Okay.
it's not going to apply in the vast majority of circumstances. And I would hate for this bill to require every Georgia operator, regardless
Redo
of
all
whether
their
they're going to use
agreements.
this, to make this change. So I agree with Mr. Zucker's suggestion, perhaps something along the lines of the notice shall state in bold type, and then the language in 166 through 169.
Okay. So let me wrap my head around. So I think what we would do is at the end of 169, strike the period, insert a comma, and then put provided said agreement states in bold type, no smaller than 12 font, 12-point font, and then that's where the language we put. We need to put the language back in from 165, but we need to just say if occupant fails to reject in writing such rental agreement, because they can sign it and it be valid. They can take no action and it be valid. We have to tell them, you have to notify us that you don't want this agreement. That would be what you have to put on there in the disclosure somewhere, right? Because you're not saying, because you're having to tell them they have to do something proactively now because you sent this agreement to them. Then they have to do something to reject it. So what does that language look like?
The remedy that the tenant has, Representative, is to move out if they don't agree with the terms of the contract. They can move out, because I think it creates additional ambiguity if they have this option to reject, and then we're still in this.
It's still stay in possession.
Yeah, we're still in this nebulous place of, well, they don't have, they're there, they're paying, but they don't have an agreement.
So what does that language look like? So provided said agreement states in bold type, no smaller than 12-point font. Failure. to execute this agreement within 14 days.
So execute the agreement and remove all property from the unit or whatever.
Well, I didn't know if we say within 14 days, and then we want to just reference to some trigger about how they get out of there.
Or you could just put the language or reference internally to the statute, or just say or the tenant vacates or terminates and vacates their storage unit, because that would be the option that Mr. Doherty's identified, is they would either sign it or, as Representative said, terminate and vacate, or their continued use of the facility shall be deemed an acceptance of the rental agreement.
Your next month's rent payment deems it accepted.
Yeah.
No, continued use. Continued use. I'm so sorry, gentlemen.
Yeah.
So help me. I'm struggling with what the language looks like there, Mr. Chairman. I'm trying to do it on the fly here, but I'm just struggling to figure out exactly how that language, how it reads.
Representative, are you trying to make the tenant aware that if they continue to occupy this space, they're bound by the agreement, or are you trying to make them aware that they have the option to move out?
Like I have a rental unit with one of my buddies, I rent from back in Cedartown. I know every year I renew it, but I don't know when the thing expires. I don't think half the time he knows when it expires. I think sometimes he'll just say, "Hey man, it expired 2 months ago. This is what's going to be for the year. Can you cut me a check?" And I always do. I think my question is, most people don't keep up necessarily with when this may happen, and that there's. So I'm just thinking, I'm thinking about not just a situation where somebody's moved in. I'm thinking about the person who is there, and they all had a good agreement. You send them new terms, and they don't know what the terms are on the renewal. That's what I'm just trying to work through.
One thought, and I don't mean to make it even more overly complicated, but if this is about, if I keep putting my stuff in, if I bring my lock and I put my stuff in, then I'm on the hook. Why don't we make a notice that you put on the door that says, by putting your stuff in here? I mean, something more articulate, but if use of this unit is a agreement to the language in whatever, and if you've lost the copy of it, call this number and we'll give it to you. I mean, then they've gotten it. We know they see it. If they put their stuff in there, they've agreed.
We use a lot of QR codes at the stores for people who want to rent after hours. They just scan the one to make the payment or scan the one to rent the unit.
But you still got to put your stuff in. You got to go to the unit sometime, and if you don't,
What if it's been there? Like I'm worried about a renewal by inaction.
well, that can we make? I mean, if we're trying, and I feel like this is. I've been trying to figure out what is going on here. I think it seems like what's going on here is we're trying to rectify a situation that's already happened. Mm-hmm. Can we do that anyway? I mean, this is not going to apply retroactively.
No, but you can apply it to make it perspective so that they don't have a problem in the future. That's what they're trying to do.
But then they're definitely not gonna have any notice that we did this, and that their failure to sign the agreement 5 years ago because they put their stuff there makes them on the hook for the payments.
Yeah, and I think we may need some language, now that you say that, about this will apply into agreements entered into on or after.
I'm assuming these agreements you don't sign one and it has a perpetual duration automatically. It renews periodically every so often. So what I'm understanding we're doing is, to Representative Evans' point, we are trying to help y'all out of a situation that you find yourself in, but I'm not so sure you can do any more than you're already doing to try to avoid it from happening, because we constantly underestimate the ingenuity of the human mind to get something that it wants for free. So, I mean, people can steal cable despite all of our best efforts to secure that. I would think they can surely figure out a way to effectively steal the use of a unit for some period of time. And so it seems to me what we're trying to do is come up with a way that to Representative Kelly's point, does not require a traditional affirmative act, that is signing a written rental agreement, but where you could imply acceptance by either their refusal, their failure to respond, or their failure to vacate something of yours that they're using. And so this seems like a pretty reasonable approach to it. I think Representative Kelly's got some concerns about just validity of notice and actuality of notice.
I think I just got it.
Go ahead.
So, because I looked down at subsection B, so I think that's where I wanted to go. So, I think we could just say, provided said agreement states in bold type, no smaller than 12-point font, failure to execute this agreement within 14 days shall result in the termination or non-renewal of the occupant's rental agreement.
Second.
But what if the
If that's in
person
order, Mr. Chairman.
wants to keep paying and wants to keep staying? Their continued use is how it's always been handled by you all before. The lease that you gave us all those years ago, language said it's a month-to-month lease. All Georgia leases are month-to-month that automatically renews by your continued use. In other words, you pay the next month's payment, we let it keep going. And we are required to give 30 days notice and change of any terms. We have a process you gave us for that. We do all of that. But this is, I think, continued use is the magic bullet, so to speak, to imply their consent. They keep paying for it.
Yeah, it's implied acceptance, I would think. Yeah.
Representative, we're not looking to have that agreement terminated if they don't execute it. We're looking for them to be bound by it.
So you can use your remedies.
I would suggest, if I may, that the language in the bold type notify the tenant that they're bound if they don't move out. I mean that's what we see in our Netflix or cable or whatever we might have. If you continue to use this service after such and such a date, you're bound by those new terms. And perhaps just a second sentence here, something like the written rental agreement shall be accompanied by a notice in bold type, minimum 12-point font, notifying the tenant that notifying the occupant that the occupant's continued use of the storage space shall be deemed an acceptance of the rental agreement, and such rental agreement shall be enforceable against the occupant as if it had been signed by the occupant. So they know very clearly, hey, if I stay, this is my deal. Yeah, this is my agreement.
But we need to reference that failure to.
I think the failure is implied. I mean, it's essentially the flip that if you stay, you're bound, and so.
What does stay mean?
Continuing to store
Pay.
your property there.
And paying the rent.
That's implied with the continued use, is the continued occupancy of the space. That triggers the enforceability of the contract, even if they don't sign it by their continued use. I've heard Chairman reference to implied. I mean, that's ultimately what we're doing here is triggering implied consent by their failure to vacate.
What if there's someone who's moved all their property out?
Okay.
And it's even not secured. They don't think they're in a rental agreement with y'all, but y'all think they are, and so y'all haven't rented their space because you think they're still there. I guess I'm just.
I can solve that now with Section B that you're giving us, which is the notice of termination. So if there's any ambiguity on a tenant who's not moved out but not told us, not signed an agreement, either that remedy of termination would apply now to this notice, or we would do a lien foreclosure because no one's paying rent on a space. There'd be nothing to sell, but we would go through the foreclosure process. I mean, those solutions are addressed, I think, in the statute and what might be added to the statute. I concur with you about the language. I have no problem, and I think the group agrees that we could add language here that notice be given with bold language about that duty.
I don't know what that language looks like. That's what I'm trying to figure out.
Do you not think that the
Read it to me again.
Well,
The written rental agreement shall be accompanied by a notice in, you had the language on the bold type, notifying the occupant that the occupant's continued use, and this is starting at line 167, the occupant's continued use of the storage space shall be deemed an acceptance of the rental agreement, and such rental agreement shall be enforceable against the occupant as if it had been signed by the occupant.
Okay, so you would.
I would suggest taking the language after the comma in line 167 to the end of 169 and requiring that in bold type in a notice to the tenant accompanying, I keep using the word tenant, the statute uses the word occupant, notifying the occupant along with this rental agreement, here's the rental agreement and here is the notice explaining to you what happens if you fail to sign this but continue to occupy the space.
So then the notice would kind of go back to what I've was the framework, strike period, comma, provided said agreement states in bold type, no smaller than 12-point font. The occupant's continued use of the storage space shall be deemed an acceptance of the rental agreement, and such rental agreement shall be enforceable against the occupant as if it had been signed.
Correct.
Okay. Okay. That would be my motion.
All right. Representative Silcox.
Thank you, Mr. Chairman. I was just going to say, I think that they should be able to email it. If they don't respond to the email, then they should have to mail it. But I think they would do that anyway.
My problem is that you could have a renewal situation that happens through no fault of either side.
No, I understand. If they don't respond to the email and they don't sign the document, then arguably there's not a contract. So they would have to mail, correct?
Representative, yes, that is correct, and I believe to the point that Representative Kelly had made earlier, if it goes out by email and the person returns that executed, it's now a valid contract.
Correct.
To Representative Kelly's point, it's that
if it goes to
if it goes out
spam.
by email and they don't sign,
Right.
you can't then bind them by that, and we find that to be an acceptable
Right.
balance.
And I agree with that. I'm just saying that if they don't sign it by email, then they should have to mail it out. They will mail it out
Yeah,
because
that's
they want a
correct.
written agreement,
That's
so that they want one.
Well, they still can email it. This is just saying they don't get the default acceptance without some way to verify the person has it.
Correct. Yeah. Correct.
But if they have their stuff there, then arguably they have accepted it because they're using the space. Does that make sense?
Mhm.
I agree with you that technically there's not a contract, but by use of the space, they're using. They know that's not their space. I mean, they know that's
No, I mean, I think it could be someone who wants it to be their space, but may not understand. It may have been a good tenant, but then doesn't understand that they're changing the terms.
Okay, and I understand your concern with the renewal, but I think they send notice of a renewal if the terms are going to change.
We're required to send 30 days, and we have a process for that already that requires notice for change of terms or rental rate. This is a different thing.
Correct.
Mm.
Okay. I think we're good.
All right, we have an amendment.
We've already approved the email strike, though. We'd have to undo that amendment.
That's right.
But see,
Any changes or additions to amendment number 2?
See, I'm confused because I don't like the email. I mean, and that was because I have a scenario in my mind, and I think they said not having the email option in section A is fine, but keeping it everywhere else.
Yes.
Okay. I'll leave it alone. Trey.
I'm trying to be able to support the bill.
So what's our posture? Where are we at?
I made I've got the second amendment that I've offered. I made a motion to it. I don't know if I've got a second.
So you hadn't yet, but do you have any changes to it before I ask for the second?
No.
This is the one you want?
Yes.
All right. Can you repeat it just
All
so
right.
that we make sure we have it?
Provided said agreement states, all right, at the end of 169, strike period, insert a comma. Provided said agreement states in bold type no smaller than 12-point font. The occupant's continued use of the storage space shall be deemed an acceptance of the rental agreement, and such rental agreement shall be enforceable against the occupant as if it had been signed by the occupant. Is that good?
Any further discussion? I'm sorry I asked that question. All right, I think we got it. All those in favor of amendment number 2, say aye.
Aye.
Any opposed? Yay. A technical legal term there, yay. All right, so we're on the bill now. Do I hear a motion? Oh, okay. Are there any further amendments?
No further amendments.
All right. Any further discussion? Thank you. All those in favor of the passage of this bill as amended, say aye.
Aye.
Any opposed? Yay, the bill passes. Goes on to rules.
Thank you all so much.
Thank you.
Thank you.
Thank you, Mr. Chairman. Thank you, members.
You all have had a quite long day today, haven't you?
We have.
Are
We
they
have.
usually this long?
A lot of times.
Yeah, it's typical.
Yeah.
When is crossover day this year?